Thank you. Now, are you? Okay. Now, is your meeting Monday? Correct. Okay. Yes.
Yeah. All right. Good evening, everyone. At this time, I'm going to call the regular meeting for the Board of Adjustments and Appeal for April 23rd, 2025. At this time, let's see, what am I supposed to do? Here we go, wrong page. It's not on here. At this time, if you would all please stand if we pledge allegiance to the flag. Thank you. You may be seated. May we have a roll call vote, please?
Chairman
Roll
Taylor,
call. Here.
Vice Chairwoman Van Deven.
Here.
Member Beckles.
Here.
Member Green.
Here.
Member Wheelis.
Here. Very good. So we have a full quorum tonight. And welcome. First order of business is approval of the minutes from March 26, 2025. First up, are there any corrections or additions anyone has noticed in reading them?
None here.
Not seeing any. I'm sorry, you have something to the minutes? Yes, sir. Oh, well, okay. Open this up to the public about the minutes. Anybody object? Okay. Go ahead, sir.
Eric Page, Hudson Bowen, 4301 Boy Scout Boulevard, Suite 300, Tampa, Florida, 33607. And I am here on behalf of the permit holder, Apollo Gardens. My only comment is minutes are really hard to keep in an hour and a half, 2-hour meeting. And in looking at the minutes, it identified who spoke, but it doesn't identify what they said, other than Ms. Conklin and myself and members of the board. So we've provided a binder that includes behind tab 6 a verbatim transcript that was taken by a court reporter. So I would ask that the minutes be supplemented by that transcript so that the record is clear as to what all transpired during that hearing and what was said. I have no problem with the minutes as written, other than they don't provide all of that detail as to what was said and taken down by the court reporter.
Are you
Very
asking
well, sir.
for
Let's ask,
specific to Exhibit 6?
I believe that the entirety of what we've submitted should be in the record because it's been submitted before the hearing, but specifically I'm asking that the board adopt the transcript from that hearing that's attached behind tab 6 as a supplement to the minutes, so that if someone goes back and looks at the minutes, they will recognize what was said in the entirety during that hearing, rather than just the abbreviations that are included in there, recognizing folks that spoke and their address and things along those lines. Not asking for any alteration to the minutes.
This is new territory for me. Someone.
Mr. Chairman, I believe that without ample time to review the document submitted, we can't even address it.
And I would just say to that, it's taken by a certified court reporter. So it's the same as if we were in a court of law and they were sitting there during a trial in terms of its content.
I believe we could accept it as evidence. I don't believe we could accept it as the transcript of the minutes without review.
I understand your position, and that's fine. It's in the record otherwise, so I appreciate it.
All right, sir. This is new to me. We've never had anybody outside object to our minutes besides ourselves.
If the board is inclined to incorporate Exhibit 6 as a supplement to the minutes, that would be something you could include in your motion when you approve the minutes. I'm not obligated to, of course, but the individuals, of course, allowed to ask you for that.
Well, seeing how nobody up here has seen this before, well, now, I didn't even open the book up earlier. Is it attached as a document, or is it?
There's a binder in front of you.
I'm holding it right here. But do we say, how do we reference it in a motion? I'm sorry. That's what I'm trying to get at.
Mr. Page has also sent this material electronically. I would reference it as Exhibit 6. That's what he has provided here and referenced here.
Okay. All right. Well, any other changes or anyone noticed? I didn't see any. Could I have a motion then with this addition to the minutes?
I make a motion to accept it as a supplement to the minutes.
Okay, as Exhibit
6.
6. All right, I have a motion and do I have a second?
Can you make a second and say like, upon review or something, because like Richard was saying, we haven't even seen this. I mean, can you add something to the motion to say like,
I believe Mr. Page said it was a certified copy from the court reporter. That's about as close as you're going to get to the minutes that are usually accepted. And we did note it as a supplement to the minutes.
okay.
So do I have a second?
I will second the motion.
Is there any further discussion about this being a supplement to the minutes from the March 26th meeting?
Mr. Chairman, I would stipulate that it be subject to further review, accepted, but
You can speak up in the mic more.
accepted, but subject to further review.
All right. Okay. Does your motion hold to that?
Yeah, motion to accept the Exhibit 6 as a supplemental recording, certified copy of the minutes from the hearing, and stipulate that it's accepted upon review.
Okay. All right. And your second holds then?
Indeed.
Very good. Normally, now I'm going to have roll call. Roll call, please.
Chairman Taylor,
Yes.
Vice Chairwoman Van Deven,
Yes?
Member Beckles,
Yes,
Member Green,
Yes.
Member Wheelis.
Yes.
Very well. So that is taken care of as a supplement, sir. All right. Approval. Okay, now it's time for me to do a little reading. All persons who anticipate speaking on any public hearing item must fill out an oath card to be heard on that agenda item and sign the oath contained thereon. The cards are located on the table near the entrance to the council chamber, or they may be obtained from the recording secretary. This meeting will be conducted in accordance to the procedures adopted in Resolution Number 24-1997. Those speaking in favor of a request will be heard first, those opposed will be heard second, and those who wish to make a public comment on the item shall speak third. The applicant may make a brief rebuttal if necessary. The representative for either side, for or against, may cross-examine a witness. Anyone who speaks is considered a witness. If you have photographs, sketches, or documents that you desire for the commission to consider, they must be submitted unto evidence and be retained by the city. Please submit such exhibits or to the recording secretary. Staff, have all the agenda items on tonight's agenda been properly advertised?
Yes.
Has any member here visited any of the sites in person or had contact with anyone that is going to be speaking tonight?
I've driven by several of the sites. Eddington Drive sites don't have the addresses, and the Apollo Gardens site as well.
Did you speak to anyone?
Absolutely not.
Very good. And I have not had any comments outside of this DS for the last couple of months. All right. So, that's over here. At this time, there is no consent agenda items. We have had a request to move up one of the items that are under new business, number 8B, variance 9-2025, at the request of the applicant for reasons of a child. Do I have a motion to move this to the beginning of the agenda?
So moved.
Okay, second?
I second the motion.
Okay, all those in favor, say aye.
Aye.
All right. So we're going to move, staff, we're going to move variance 9-2025 for 1311 Wilderness Drive to the first item to be heard. And if you tell us what page to go to in the computer, please.
Thank you.
Thank you. Variance 9, beginning on page 152 of your packet.
152, is that correct? All right. Oh, yeah, that helps. Thank you.
You're welcome.
Go ahead.
Okay. Variance number 9-2025 for 1311 Wilderness Lane. Variance request is to Land Development Regulations, Chapter 30, Section 30-182, Height and Location Requirements, to allow a fence located in the front yard to exceed the maximum 4-foot height for property located in the multifamily high-density zoning district located at 1311 Wilderness Lane, as submitted by Alyssa Antilles, owner. Sorry. Go over the powers of the BAA. LDR Section 34-226 states that the board shall grant a variance request when, in the opinion of the Board of Adjustment and Appeals, owing to special conditions, the literal enforcement of such ordinance or regulations would do manifest injustice to or impose an unnecessary hardship upon the applicant. In order to authorize any variance to the provisions of such ordinance, the board must consider the following criteria. A, special conditions and circumstances exist which are peculiar to the land, structure, or building involved and which are not applicable to other land, structures, or buildings in the same zoning. B, special conditions and circumstances do not result from the actions of the applicant. C, granting the variance requested will not confer upon the applicant any special privilege that is denied by ordinance to other lands, buildings, or structures in the same zoning district. D, the literal interpretation of the provisions of the ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of the ordinance. E, the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. F, the granting of the variance will preserve the spirit of the ordinance and remain in harmony with its general purpose and intent. G, in granting the variance, the public safety and welfare must be assured. And H, in no case shall granting of a variance result in a change of use which would not be permitted in that zone. Now for the variance analysis, Land Development Regulations, Section 30-182 of the LDR states that the maximum height of a fence or wall in any required front yard setback shall be 4 feet. The applicant is requesting a variance to the LDR to allow for the construction of a fence 6 feet in height within the front yard along Wilderness Lane. The subject property was platted in 1986 as part of the Titus Woods Townhouse subdivision. The property abuts Tract A, an ingress and egress, drainage and utility easement operating as a private right-of-way. LDR Section 30-181H states that no fence shall encroach into a visibility triangle at an intersection or a driveway as determined by the city. And the city engineer has reviewed the proposed fence and confirmed that it does not encroach into the visibility triangle. However, the subject lot does not appear to exhibit any special conditions or circumstances that would necessitate a deviation from the standard 4-foot front yard fence height. The applicant has the ability to provide privacy and screening through the installation of a vegetative buffer along a 4-foot high fence, thereby achieving their stated goals without requiring a variance. Staff recommends denial of the variance. There are no special conditions or circumstances that exist which are peculiar to the land. The literal interpretation of the code would not deprive the owner of rights commonly enjoyed by others in the same zoning district. The plot plan for the fence is on page 175 if needed. And with that, if you have any questions, I am prepared to answer.
Are there any questions of staff? Anyone? No, we're asking staff right now. We haven't opened it up for public hearing yet. Okay, so this drawing on 175 that we have in our packet with the green is the location of the new fence. Is that correct?
Yeah, for the fence, there's no
Or the
current fence.
there
yes,
is no fence
correct.
now, but that would be the fence. And that is a corner lot, as we said.
Yes.
Okay. Any other questions of staff? None here. Okay, we will open this up to the public hearing at this time. And our first card, please, ma'am.
It'll be the applicant. She's going to have to give me a card after she's done.
Okay. Ladies and gentlemen, if you wish to speak on an item, you must fill out a card before the item is called, before we get into the hearings in the future, okay? So if you've not filled out a card, please go fill out a card, bring it to the recording secretary. That's what I read earlier. I know it put everybody to sleep, but. Thank you. Would you come up, please, and give us your name and address for the record, please?
My name is Alyssa Antilles, and I live at 1311 Wilderness Lane, Titusville. Okay.
Okay. You give us a reason for this extra footage that you're wanting, need, ma'am?
Yes, I know I put in the answers to the questions and put in an attachment. I thought that I could either bullet point or read it.
Yes?
When it says, why am I not able to comply with the requirements, and what hardship am I in justice or am I in claiming? I need to put the fence in my front yard to protect my disabled child from elopement or risk of harm. I have provided verification of his condition. I gave some additional paperwork to your packet, which has government, state, medical doctor description of his condition. They're exhibits A through E. I recognize that the rule of the city is the 4-foot fence, which is too short for my son's height. He's 17, he's outside if you wanted to meet him. He's 5'10" now. Therefore, I'm requesting a 6 foot of HOA-approved PVC material, the same fence I placed in my backyard. My property, to me, they're asking if it's special and what conditions make it different than other properties. My property's not special. The variance is not something I want. It's something I desperately need. I propose to the city to council to consider the special needs circumstances of my family and allow a 6-foot fence to be placed rather than 4 feet for my son's safety. However, the property is unique, and I recognize that the city engineer did go out and look at the triangle, and I did provide photographs, and those photographs are showing the corners where it's not causing any difficulty for traffic or obstruction, which was pleased to see. And therefore, it doesn't obstruct drivers from seeing each other as they meet up on the corners of Wilderness Lane. I've provided photos, which are also in the packet. Am I asking for the minimum change requirements? I am asking for the minimum change. My hope is to just put the fence where the property line is and where the walk path through the driveway meets the front door to safely transfer my son from car to home, and then to have opportunity out in the front yard if, he wanted to enjoy it, and leave a portion of the property unfenced. There is a large oak tree. That tree has large roots, and I intend to box around it, which again, I've provided photographs with a hologram fence so that you can see where ideally I'm looking to place this. My property's an end unit. The fence doesn't cause any harm to anyone, and I do have one neighbor adjacent to me who did send in a supporting letter and stating that it doesn't affect him whatsoever. I did want to touch on the response on the city where I did come into the office and speak with them, and they politely helped me come up with solutions. However, those solutions don't meet the needs of security and safety. My goal today is to achieve safety for my son, and secure him in that fence. The 4-foot fence with the greenery around it, I don't see how the gate would be given that security. And we also have utility lines that are going throughout the front yard and putting the bushes. I don't even think they would grow if we tried, and it would take years for them to grow. So that's not giving me that security I'm hoping and really needing for my son. So I'm asking you, the council, to consider the 6-foot fence, which is actually a fence that you can at height length see over, because I'm using a specific decorative fence that it doesn't make it seem like it's barricaded. It stops at 4 feet, and then the next 2 feet are decorative. So it gives the height, but it doesn't give the appearance of a large fence. So I appreciate your consideration.
Do we have questions for anyone who want to ask this applicant? Yes, ma'am.
I noticed on one of your exhibits, you say that your son has autism, and it's an elopement kind of autism. What is elopement?
Elopement is where the child, for whatever reason in their minds, decide to wander. And they're not doing it for any intention, they're just curious. I did provide an Exhibit A. Elopement is wandering or a common behavior among individuals with autism. It's when a child with autism leaves a safe space without the caregiver's permission or supervision. Now, I keep my eyes on my son all the time, but the thing is, what has he done in the past so far? He comes outside, and within seconds, he's much faster than me, and I'm his only caregiver. So he can just, from one turn of a head, go in the other direction and quickly. And that's the thing. And he could just be following a butterfly. He could be curious to go see a neighbor's dog. He could be doing anything that's going on in his head that he wants to go see. And that's the problem. It's by no means a negligence on my part, just from that 1 second. That's why I don't believe in the shopping experience where we all do our own shopping with the checkout with no checkout people, because I can't do that without turning around to look, where is he? That frustrates me, So
Thank you.
That's it.
Anyone else have any questions of this applicant? Yes, ma'am.
Has he had a history of climbing the fence?
With elopement?
Yeah. I
Yes.
said, has he had a history of climbing over the fence?
Oh, climbing over fences? He can climb. He
No, I
can.
said, has he had a history of climbing over the fence?
We've never lived in a home to have a fence. This is my first home ownership, to have a home with a fence, to be able to know, can he climb over a fence? I wouldn't know, because I knew he would never get to that point. So could he climb a 6-foot fence? No.
Are there any other questions of this applicant? Thank you very much.
You're welcome.
Appreciate you. Do we have any other cards for this item?
Yes. Elizabeth Parker.
Okay. Welcome, Ms. Parker. If you would give your name and address for the record, please, ma'am.
Elizabeth Parker, 3446 Trevino Circle. I am in favor of this particular fence change as a parent to a child with autism. My daughter did elope. All it takes is 30 seconds with your eye off your child, and they can literally disappear. These kids are quick. A lot of them are nonverbal. And my daughter went a third of a mile away and was found by a neighbor when she was nonverbal. If I hadn't brought around flyers to introduce my neighbors to my child and explained that she was nonverbal and where she lived, and he was a good person and not a bad person, she could have been very badly harmed. Additionally, children with autism are attracted to water. Drowning is one of the leading causes of death of our children. I think it's really important that although the property may not be specifically in need, the child is. And in this community, in this world, these kids need to be protected because the only resource they have are generally us mothers. All it takes is us using the restroom at the wrong moment, and our kids can be gone. And certainly, if all it takes is putting up a 6-foot fence to assure that this young man can stay safe in his property, I can't see why the city would deny that. Thank you for hearing me.
Well, thank you. Were there any questions of this witness? Thank you very much. Do we have any other cards?
No, sir.
Okay, that ends we'll close the public hearing and bring it back to the board for discussion or a motion. Any questions of staff?
Has everyone read the exhibits that were supplied in the agenda related to this?
Yes, it was in our
We all
agenda.
Understand this is a true disability.
You need to pull that down so you can hear you, sir.
So we all understand this is a true disability, and we have an opportunity to address it in a way that is helpful to everyone. That being said, I'll make a motion.
Well, I'd like to ask a question of
Sure.
staff. Staff, there you are, sorry. If we were to approve this but restrict it to this owner and the property changed hands, is there any way to rescind it to a new property owner? Is that a far-fetched stretch, or say I don't know. I was just asking.
I don't think that's possible because I think that any variance that's granted would be issued to the property and runs with the land. And I can't think of how to craft any conditions that would restrict it to just one owner.
When it comes to zoning, ownership is irrelevant. It's about the land, the conditions of the land itself. So you can't make conditions on who owns the property, basically. So it's really about the property itself is what you're supposed to consider.
Just a question I had. All right, sir, you wish to make a motion?
I move to allow the request for variance based on special conditions.
Okay, we have a motion to approve. Do I have a second?
Second.
All right. Any other discussion? Okay, may we have roll call, please?
Member Beckles?
Yes.
Member Green?
Yes.
Member Wheelis?
Yes.
Chairman Taylor?
Yes?
Vice Chairwoman Van Deven?
Yes.
Very well. Very well. You can get with the city now, and they can give you that approval, okay? You're welcome. All right, at this time, we will go back to the order of business. And first, we have old business that we're going to. And again, this was for the appeal of 1-2024 for the Apollo Gardens site development permit. Our last meeting, it was declared that Ms. Conklin did have status, or standing, excuse me, correct, thank you, standing. So therefore, we're up to hear the appeal,
At the last meeting, the board decided to reconsider the last motion that was made at your previous meeting.
Okay, that's,
So hang on one second. At that previous meeting, Member Green had made a motion to allow standing for Ms. Conklin.
correct.
And the motion to reconsider would be to bring that motion back on the table.
Okay. So tonight, we're voting to,
So that's the first, so the
This is old
motion to
business.
reconsider would reopen the motion that was previously decided by this board at your last meeting when that decision was made in March. And so now what is on the table for the board to consider at present is whether you would like to have discussion or hear anything on the motion that Member Green made to grant standing. You can continue with that motion at this time. You can have discussion. But that was where the board decided to go at the last meeting.
Okay, I thought we decided that, so.
Oh, yeah, too.
So what are we approving then? I mean, that was approved, I'm sorry.
So there was a motion that was previously decided negatively. There was a motion that failed 2-3.
Correct.
That Member Green made to grant standing for Ms. Conklin. This board decided that she did not have standing by a failed vote of 2-3. And at your March meeting, you decided to make a motion to reconsider the previous motion, which I just described, which is now where you are today. So you are now at the point of deciding if you agree with Member Green's motion that Ms. Conklin has standing.
Okay,
Based on that,
based on that, you got it?
I would like to, I thought very long and hard on this, and it's, the matter at hand is the determination of whether Ms. Conklin possessed the requisite standing at the time she submitted the original application. Upon review of both testimony and documentary evidence, it is apparent that the significant ambiguity in the application's design may have contributed to any confusion regarding her representative capacity. Ms. Conklin consistently testified that at the time of filing, she was acting in her capacity as an agent for the residents of Royal Oak. She further indicated that she herself is a resident of Royal Oak, reinforcing her connection and interest in the matter. While the application she submitted did not explicitly state her role as an agent, Ms. Conklin credibly testified that the application did not contain a designated section or prompt requesting the applicant's title or representative status. The only field required for execution was a signature, which she provided in good faith. Her omission of the term agent was due to no express instruction or field requiring such designation. A review of the original application corroborates Ms. Conklin's assertions. There is a notable absence of any requirement or field for stating a title or representative role. This lack of clarity in the form itself casts doubt on whether it can be reasonably expected that an applicant would anticipate the need to unilaterally assert their capacity as agent in an unprompted manner. In further support, Mr. Sievers, a retired attorney and witness for Ms. Conklin, testified to the following. The application should have explicitly required the title of the applicant if such designation was necessary for standing. In the absence of such instruction, it was reasonable for Ms. Conklin to assume that her signature alone sufficed. In light of the foregoing, Ms. Conklin's consistent and credible testimony indicates she was acting as an agent at the time of filing. Multiple witnesses, including a qualified legal professional, confirmed her representative role. The original application's failure to request or provide space for a title renders any assertion of improper standing unfounded. Therefore, the evidence supports a finding that Ms. Conklin had standing at the time of the application's submission, and that any questions regarding her representative capacity stem from deficiencies in the application form itself rather than any omission or misrepresentation on her part. That's what we're here to decide.
All right. So now we are back to the original motion. Do we want to reopen the original motion? Is that correct?
Yes, I believe you are at that original motion now.
Okay.
And it would be appropriate for the board to either continue discussing or vote on that motion.
All right. Not yet. We'll discuss first, okay? Are there any questions anybody has up here first before we take input from anyone else about proceeding with this?
I don't believe we need input from anyone else.
Okay.
At this point.
Very good, sir. All right, then do I have a motion to proceed?
The motion has already been made by Mr. Green. I believe we're calling the motion.
No, that's what we voted on last time.
No, that was correct. It was 2 months ago. Mr. Green made a motion, it was seconded,
Okay.
and that is the motion that you're now reconsidering.
Okay, we're motioning that, okay, because the vote got changed. Okay,
The vote is happening again.
On standing.
On Sandy, we had to do that again. All right. So maybe I have roll call on that, please.
Sir, I'm sorry, but I do have a point I'd like to raise that concerns the motion for reconsideration that got us where we are today. And there's a motion in the packet that I've submitted to the board that addresses the procedural nature of the last year.
Just a moment, sir. You're not on the record. You're just speaking from the table. I guess we have to open up everything we vote on. Is that right? Or not?
I think that it is up to the board to decide whether, at this point, they would like to hear additional testimony. That's the question, yes.
Okay, this is on stand.
I think that's a procedural question that Mr. Page is trying to make about the motion. And to avoid any legal arguments later, you may want to hear what he has to say and then continue with your motion. I would give him no more than 3 minutes.
Is that agreeable with everyone for 3 minutes? Right? Very well, sir. Come to the mic, please.
I appreciate your indulgence. Eric Page again on behalf of Apollo Gardens. There's a motion in your packet that I'm going to amend a little bit. It was a motion to revoke the order granting the motion for reconsideration and to deny the motion for rehearing. The problem we've got, and Attorney Farrell was good enough to point out to me that the City Council Rules number 13 says that a motion for reconsideration can be brought up at a subsequent meeting. That's different than Robert's Rules. Robert's Rule says it has to be within the confines of the meeting where the decision up for reconsideration was made. So it's different. So what happened with raising the motion for consideration of the subsequent hearing, I am no longer arguing that that was improper. The problem is that the City Council Rules, Rule 18, also adopts Robert's Rules. And Robert's Rules specifically say regarding motions for reconsideration, and this is in the motion that's behind the first tab in the binder, and I quote, "If reconsideration is moved while another subject is before the Assembly, it cannot interrupt the pending business." And the pending business and the only pending business that day was the motion for rehearing. The motion for rehearing should have been considered. It should have been voted on. And whatever that resolution was, is that resolution. But to not address it when it was on the agenda, it was the only noticed item, would be improper as a matter of law. The motion for rehearing, if addressed, would have failed, because the motion for rehearing and the motion for reconsideration were on the very same thing. They're on whether or not this board was going to reconsider Ms. Conklin's standing. And the motion for reconsideration passed 3-2. 3 votes is insufficient to grant a motion for rehearing. It should have been heard, and it would have failed. Last point, and this is again in the binder that's presented, this is what Mr. Severs presented a month ago. There's an article in here. The article's 15 pages long. He gave you 5 pages. He took out 10 pages. Here's what was on the first page that he admitted. This is the Renard standard. The seminal case on standing in this non-applicant context, which we have here, is Renard v. Dade County, which identifies 2 different standards that depend on the nature of the challenge. One's procedural, one's substantive. I'm not going to talk about procedural because Ms. Conklin's challenging substantive. If the non-applicant, here Ms. Conklin, is squarely challenging the substantive decision, such as whether the local government correctly applied the Land Development Code in granting the landowner's development application, then only those suffering special injuries from the decision that differ in kind rather than degree from the rest of the community have legally recognizable interest to support standing. Ms. Conklin does not have that. Any of the people who have tried to make her their agent do not have that. There's no competent substantial evidence in this record for any of those folks or for Ms. Conklin. And I'll just note that kind versus degree is further defined in that article.
Thank you, sir. Somebody shut up. Excuse me, just a moment, please. All right, thank you. Thank you, sir.
Any questions?
Are there any questions? No, thank you.
Thank you.
More?
This board has decades of history using Rule 13 and the motion to reconsider. And I do not agree that there's any problem with you all moving forward, as has been previously addressed by myself, as far as you all have the ability to reconsider a previous decision at the same or the very next meeting, which is what you have done, and it was put on the agenda for tonight with due process to provide notice to the community to attend tonight's meeting and move forward with your motion and decision.
Thank you. All right. Ms. Conklin, you still wish to address, even though what you just heard? You
Yes,
also
sir, thank
get
you.
3 minutes.
Vicki
please.
Conklin, 2920 Royal Oak Drive, Titusville, Florida. I would just like to point out, this is the Donovan article, and actually, the whole thing was in your packet, and it's a really good article, because he's really, really good at citing all of this. But there is one portion that talks about, and it's on page 110 of your packet, and it says, standing to challenge decisions not controlled by statute, the Renard test. And that's what I believe that Mr. Page is referring to. That's not the issue here, because the challenge that we have today is according to statute. And that would be page 120 of the same article, and it's standing to challenge decisions covered by a Florida statute, and that's statute 163. So I believe that he's maybe confused about what we're doing here tonight. And
Thank
I
you.
have further comments on standing if you should want to hear those.
No. Well, you'll be later. Yes. All right. So, do I have a motion to reopen? Yes, sir. Or to continue with the motion previously denied. Is that correct? Is that what I'm doing?
I think you're looking for a roll call.
Okay, roll call. Okay, we're down to roll call. So, yes
Member
or no?
Wheelis?
Right? Yeah, go ahead. I'm sorry.
Yes.
That was 2 months ago. Can we hear?
The very first motion that you were here failed 3-2.
Right.
It was brought back up at the last meeting.
But I want to hear the motion again, is what I'm saying. Because you keep saying the motion, it failed, blah, you weren't here, it blah, blah, blah. It what? I mean, I want to hear specifically what the motion says.
Well, I've slept since then, but let me know what page it was on, and I'll read it again.
And this is to find that Ms. Conklin has standing. And if you remember the first hearing, the issue was that she signed her signature.
Can I
and
hear the
didn't put age.
motion again? I'm asking you to hear the motion again.
Okay. The motion is,
I don't need the
does Ms. Conklin have
explanation.
standing?
Could we have the clerk read back the motion? I understand.
Or can you tell us what your motion said?
We've had several meetings and a lot of motions and a lot of emotion in this room over this. The motion is to let Ms. Conklin approach and hear the argument from, or the details of neighbors that are affected by this development to have their say to us.
Chairman, the February meeting minutes state specifically, Member Green made a motion to approve applicant's statement of standing in this case. Member Van Deven seconded. That's what I read from the February meeting minutes. That's the motion.
Thank you. Good grief.
Okay, so we're doing roll call now, please.
Member Wheelis?
Yes.
Chairman Taylor?
Yes.
Vice Chairwoman Van Deven?
Yes.
Member Beckles?
Yes.
Member Green?
Yes.
Thank you, thank you. Okay, so do we have all the exhibits and everything, Counselor, to open this back up again tonight for the full hearing? Are both parties ready to go with this? All right, I see concession. All right, staff, read us in, get us started again, please. And what page are you on?
Page 14 of your packet.
Thank you.
It's a report to the board. Staff's recommendation is to concur with the administrative interpretation and deny the appeal. In summary and explanation, Apollo Gardens Apartment site plan was approved on September 19th, 2023, On November 11, 2024, Site Development Permit, PSDP 24-000205 for project number J22-5424, the Apollo Gardens Apartments, was issued authorizing on-site construction. On December 5, 2024, Vicki Conklin, appellant, submitted an application to appeal the approval and issuance of the site development permit. Prior to consideration of the appeal, the board must determine whether the appellant is an affected property owner, which you've already decided. On January 29th, the board tabled the appellant's appeal to the February meeting. On February 26th, the board determined that the appellant did not have standing. And then on March 26th, the appellant requested a rehearing, and the board instead adopted a motion to reconsider, and so you decided that tonight. So what you have, what I'll start with is the staff report on page 31 of your packet. In the packet, you'll see the applicant's application and their exhibits, but I'm just going to start on page 31 and just go right into our staff analysis. The location of the property is at 2727 Demerit Drive, tax number 2207868, parcel 2235160034. The zoning on the property is multifamily, high density, which is R3. The administrative interpretation, Apollo Gardens site plan was approved on September 29, 2023, consistent with the land development regulations and the comprehensive plan. On November 11, 2024, the same site development permit, which I already stated, for the Apollo Gardens Apartments was issued authorizing on-site construction. On December 5th, 2024, the appellant submitted an appeal pursuant to section 34-250. The notice of appeal shall be filed in 30 days. All that was followed. The Apollo Gardens project is a multifamily apartment building with 84 residential units. The property is zoned, again, R3, multifamily. The project is permitted in the R3 zoning district. The property is designated with the comprehensive plan high-density residential future land use designation. The property has frontage on Demerit Road, which is a public right-of-way. According to the appellant, the Apollo Gardens project is not a conventional multifamily development and is not consistent with the comprehensive plan future land use element strategy 1.13.11, policy 1.14.5, and policy 1.14.6. We believe the appellant was referring specifically to policy 1.14.16 on that last one. The comprehensive plan and the land development regulations do not define a conventional multifamily development. The LDRs define multifamily dwellings as a building containing 2 or more dwellings per Chapter 37 of the city's definitions. The LDRs do not distinguish between an owner-occupied condominium-type multifamily development and apartments for rent. Multifamily dwellings such as duplex, triplex, quadruplex, or et cetera, are permitted in the R3 zoning district per Section 28-54 of the city's zoning use table. The R3 zoning district is consistent with the high-density residential future land use district or land use designation, Section 27-21 per the land use zoning consistency matrix. Strategy 1.13.11, we believe is not applicable to the Apollo Gardens property. The strategy describes the US 1 quarter future land use district, which was specifically created to implement the US 1 quarter master plan adopted in 2007. The property is not located within the boundaries of the US 1 quarter master plan. Policy 1.14.5 is also not applicable to the Apollo Gardens property. The policy describes the medium-density residential future land use designation. The Apollo Gardens property is not designated medium-density residential. The crux of the appeal is truly specifically to policy 1.14.16, which is applicable to the Apollo Gardens property. The policy describes the high-density residential future land use designation. In 1988, the City Council adopted a comprehensive plan. The City Council also designated several properties, including the Apollo Gardens property, with the high-density residential land use district consistent with the comprehensive plan. The policy was cited as Objective 10, Policy 1D, and stated the following. High-density residential uses, in parentheses 9.1 to 15 units per acre, or mobile homes shall consider existing and proposed land uses to ensure compatibility. Further, such density shall be located adjacent to at least a minor arterial street. The City Council determined consistency with the comprehensive plan, including the policy statement related to densities located adjacent to at least a minor arterial street, which we believe are Harrison Street and Barnett Avenue are the only adjacent streets that would have qualified as minor arterial streets. The appeal is based upon the current policy, which was amended in 2007, 19 years after City Council had determined consistency with the comprehensive plan and designation of the property as high-density residential, to state the following. High-density residential uses, in parentheses, maximum 15 units per acre, or mobile homes shall consider existing and proposed land uses to ensure compatibility. Further, such densities shall be located adjacent to at least a collector or arterial street unless the property is located along the following local road, which already has a multifamily development pattern and is capable of supporting higher density, which is Rockport Road, parentheses, from Tropic Street to South Street. Harrison Street and Barnett Avenue are collector roads according to the city's land development regulations. The property is consistent with the policy statement related to densities located adjacent to a collector. The permit was issued consistent with the comprehensive plan, including the high-density residential land use designation policy. Enclosed, we've included maps identifying the location of properties with the same land use designation for your reference. The recommendation is to concur with the administrative interpretation and deny the appeal. With that, I'll try to answer any questions you have.
Are there questions of staff at this time? And staff has concurred with council for the city that this action is correct. Is that?
I don't understand the question.
Did staff consult with council with the city that their interpretation was the correct interpretation?
That the staff's interpretation?
Well, you just gave us staff's interpretation, right?
This is the administrator of the code providing an interpretation and review of a site plan, and we
Okay.
found it to be consistent with the comprehensive plan.
Okay, you found it consistent. Okay. Thank you. Any other questions? Okay. All right. Then I guess we open it up. And Ms. Conklin, I believe you'll be the first one as you are the applicant, correct? Please come forward.
Again, I thank you for your time. I thank you for your patience the past 4 months as we've navigated this appeal together. I think that the BIA mainly deals with variances, and that's been my experience from all my municipal experience as well, with people asking for permission for things that are outside of the city code to do. But today we are asking for an appeal, and that is we're simply asking the city to follow the city's comprehensive plan. We're not asking for a variance. We're not asking for rezoning. We're not asking for any changes. We're just asking to adhere to the comprehensive plan, the Florida statutes, and thereby avoid placing the city in legal jeopardy. We're not here about merits of the affected property, whether you think it's worthwhile or not worthwhile. That's really not why we're here. Our appeal is with the city of Titusville. We live here, we work here, we play here, we pay taxes here. This is our chosen community. We're residents. We have limited incomes, many of us on fixed incomes. We're not a large corporation, being able to bring in multiple attorneys, pay them $4,000 or more to be able to send threatening letters to whoever opposes us. We can't do that, like I receive threatening letters from the opposition's attorney. That doesn't seem to be a right thing to do. We paid $625 to come before you all as a board to present what we believe to be the facts. Regarding Mr. Page's comments, I feel a need to address them at the March 26th meeting because he challenged the significance of the 8 authorized people who signed naming me as agent. He challenged the significance of the 33 residents who attended the meeting and spoke to you all. He challenged the significance of 27 new authorization letters that were submitted for the March meeting, and those were letters of residents adjoining 2727 Demerit. Their property actually abuts it and joins to it. And some of those records that we submitted to you were the HOA presidents that represent Spanish Oaks condos, which is 84 units, and one was a Village Square HOA condo representing 104 units. So when we add all of those together, it's a lot of people that are very concerned about this development. Mr. Page also challenged whether the new authorization letters could have been presented earlier instead of waiting, and that seemed very important to him. And I feel a need to answer that just for the record. My 94-year-old mother died on February 21st, 5 days prior to our March meeting. I spent those 5 days making funeral arrangements with my family and familiarizing myself with our presentation because that was important to me. The very next day, I flew to St. Louis, Missouri for the funeral of my mother with my family. Upon my return to Titusville, I began meeting with other residents, and they urged me, they wanted to sign this to authorize me to be their agent. And so that's the reason for the delay. That's why I had to wait till I got back from my mother's funeral to get more documents. I hope that's satisfactory to you, and any of you who have lost a loved one recently can identify with that. I don't feel any burning obligation to explain anything to you, Mr. Page. My appeal is to the city staff decision, not your project. But in the interest of transparency, honesty, and with no hidden agenda, I'm choosing to share this personal information, and I hope you can appreciate that. So I'd like to clarify the city's appeal application process. The document, as I appreciate Ms. Van Dieven saying, is for the applicant. And so I appreciate the fact that that was reviewed because I did the best I could with the form that I was given. I also believe that the BAA's role is to consider applicants' requests for variances on appeals and to determine if the request follows or doesn't follow the state statutes and the city code. It's not whether you like the project, don't like the project, but it's a yes or no. Does it meet code? Yes. Does it not meet city code? No. And so that seems to be the very issue at hand. Does it follow the Chapter 163, which we'll be sharing? If not, then that appeal must by law be approved, and the staff should rescind that development permit that they issued. And I do have a presentation if you would allow me to do that now, or if you choose to wait, that's up to you, whatever you'd like me to do. I have a small PowerPoint presentation. And I did provide, that is on your laptops, and I did provide it with Kim.
Okay, or want to hear that then? Okay with everybody?
Can you tell us what it's about first?
The presentation,
What
it cites
what it specifically addresses?
why would I want to do the presentation?
What does the PowerPoint specifically address?
It addresses the justification for this appeal and the justification of why the state statutes that should be followed and the importance of the comprehensive plan according to state statutes. So it's the law of the land.
All right, go ahead, please.
Okay, thank you very much. And so Kurt has been helpful with starting, and Kurt, if you could start that one first, sir. Is to show you what happens on a typical trash day on Demerit Drive. And that's on Thursdays, and this is what happens. The trash truck arrives, and you can see it's pretty tight. The road is 22 feet wide. Yeah, ooh, we cringe when we see that each time, and they see that every Thursday. The road is only 22 feet wide, and so there's not enough room for many cars to park. Some do have to park on the road or in their yards, and they prefer to use the pavement instead. That's what you see on Thursdays if you go to Demerit Drive. In addition, there were street sweepers, there were landscaping fellows trying to get through, so this is what happens every Thursday. I just thought the visual might help you to see what we're dealing with. Now, I believe that Kurt has this set up as an overview. So this is the overview. The appeal is for the site development permit, and I named the project, which Brad is very well described, and it conflicts with the City of Titusville comprehensive plan. And so what we have here is the Florida law, and this law is really critical. It's the Florida State Statute of Chapter 163, Part 2. And I wanted to make sure that you had a copy of that if you had not had a license for that. The comprehensive plan is the primary policy document. It establishes a long-term vision, goals, objectives, and policies for the city's future growth and development. And just as stated, 163.3194, legal status. After a comprehensive plan or element or portion thereof has been adopted in conformity with the act, all development undertaken and all actions taken in regard to development orders shall be consistent with the plan or the element as adopted. This is important as well. The Titusville Land Development Regulations. This is Titusville's forms, Chapter 2712, Section J. In the event of a conflict in these regulations and the comprehensive plan shall prevail. It's the intent of the city to have the more stringent regulations prevail in the event of any conflict. And what we have here, there's a conflict between with the way the property is zoned, which was done years ago, and we'll speak about that in a moment, as well as what the comprehensive plan. So they're in conflict with each other, and the charge tonight is to decide which one weighs more heavily. We are merely requesting that the city adhere to its own comprehensive plan. The next is strategy 1.13.1.1, and that's the U.S. Quarter Land Use District. And Mr. Parrish spoke to that. I think it's important. He believes that this isn't as critical with this development, and so we'll move on to the next, which is policy 1.14.6. And this is critical. High-density residential uses with our mobile homes consider existing and proposed land uses to ensure compatibility. The density shall be located adjacent to at least a collector or arterial street. Well, Demerit Drive is a local residential road. The closest roads that are arterials or collectors, as Mr. Parrish stated, are Barna and Harrison. And neither one, they're at least 625 feet away from this development. And so Demerit Drive, a local residential road, is what's being considered for their ingress-egress, their only ingress-egress. So now we have the issue between comprehensive plan versus zoning. So decades ago, according to Brad, a previous city council designated 2727 Demerit Drive for multifamily zoning, and that was confirmed. We met with Brad in person on November 26th, and he shared that information with us. The comprehensive plan restricts multifamily access to local residential roads, and nobody disagrees about that. But here we come again to Florida Law Chapter 163, which is like the Bible here. This is the legal status of the comprehensive plan. It's the primary policy document. Thus, the comprehensive plan inherently holds greater weight balance because it dictates the overarching policy within which all development must occur. So the background, as Brad described very well, is the zoning classification that was established many years ago by a city council that's no longer in power. And what they established was that 2727 Demerit could be a zoning of multifamily. And the previous city employee, Peggy Bisaka, she certified compliance of Apollo Gardens multifamily project with the zoning and land use regulations. This is critical. She certified that it met zoning and land use regulations. It did not certify compliance with the comprehensive plan. That's a critical element. It did not certify compliance with the comprehensive plan when she signed that in June of 2022. We're concerned that this is setting a precedent. If we deviate from our comprehensive plan, it affects all subsequent development in our rapidly growing city. And this really is not an issue just about 2727 Demerit. This is an issue for the future growth of our city. in violating Chapter 163, if we continue to violate that and say the comprehensive plan doesn't matter, what will we end up with as a city in terms of any growth that we should be having? Lots of local residential streets are in our city, and if they all then get subjected to having multifamily on them, we've really changed the character of any development that we have. And it puts the city of Titusville in legal jeopardy per Florida Statute 163, Part 2, Comprehensive Plan. And so people wonder what's the difference in a local residential road? Well, we did go out and measure, as I believe I described to you before. The width of Demerit Drive and Ternessa are 22 feet. The width of an average car or truck is about 6 or 7 feet, depending on the large mirrors, of course. The width of a lawn care rig is 8 feet and 10 inches, but 40 feet long. Many residents do park on the private street. The trash truck requires 11 feet to maneuver through, as you saw. And then the yard trash truck that has the arm on it, that of course requires even more space. And so the question is, what about construction trailers trying to get down? What about fire engines trying to get through to get to a multifamily project at the very end of the road? I think they're going to have a hard time. And just so you see that visual again, it's a typical trash pickup day on Demerit Drive. Now, this is the center of the road, and so there was the lawn maintenance gentleman, and you can see the part of his trailer down. If you see to the left of the screen, you can see that's the center of the road, so there's not much more space for anybody to get through. Multifamily zoning at 2727 Demerit, it does not align with the neighboring zoning. Demerit and Ternessa residents consist of single-family residences. Spanish Oaks condos, they have access to Harrison Street, which is the arterial collector. Village Square condos have access on Harrison Street, the collector, the arterial. The nearest three-story building, standing at 35 feet, is located more than a mile away, and that's on Knox-McRae. A section of Demerit Drive has been deeded to Spanish Oaks condos just for emergency access, allowing them to install and maintain a locked gate on the southern side, and that would remain in place. I think this is important. This situation is not a hardship for Carrefour or Apollo Gardens. It's self-imposed. They knew about this prior to purchasing, prior to getting involved with this project. So any kind of hardship they might claim is one that they imposed themselves. The comprehensive plan policy was in place prior to Carrefour purchasing the property, and that was in January of 2023. So my summary is approve the appeal and rescind the site development permit for Apollo Gardens LLP. It violates the Titusville Comprehensive Plan. It sets an unlawful precedent for future multifamily developments. Multiple residents have submitted public requests to city officials in the past 22 months, asking them, please review this issue. This isn't right. It's violating the comprehensive plan. For 22 months, we've been asking, and there has been no response at all. Perhaps a few meetings, but nothing really has come of substance. So we're asking the city to follow the comp plan. So this is what it came to. It compelled us to gather our $625, pay the fee as the only way that we could come to you to explain what a crucial situation this is. We're merely asking and requesting that this board and city officials and staff adhere to the Titusville Comprehensive Plan. And the final slide, which I know Brad is familiar with from going to the different planning things. He might have even written it, I'm not sure. But the comprehensive plan is king. It does carry more weight than what that zoning of that 2727 Demerit does. Any questions? I hope that helped, Ms. Beckles, to show you. Sometimes the visual helps a lot more. Brad did give you some examples. I'm sorry, just 30 seconds more here, sir. He gave you examples, and I think that what we have to look at is what's happening in the city as a whole. This rule has been violated quite a bit. In fact, not this last council meeting, but the one before. And so we see that local residential roads, more and more, the developers getting permission to use local residential roads for multifamily, but it violates the code. And so we can cite past instances of approvals, but they were still illegal then, they're illegal now. What are we going to do moving forward? Are we going to go for what's legal? Are we going to say, we made some decisions before that probably were illegal, but we'll just keep making the same ones? And we're saying, please, stop, take a look. We're growing quickly. Let's follow the law, and let's listen to the residents as well. I believe we have some compelling reasons. Thank you.
Ms. Conklin, you've made mention of other projects that were approved. I've never heard an address or anything. Can you give me an actual location or a project that you consider that was illegal or not following the comprehensive plan?
Yes, sir, on Windover, not last night's meeting, but the previous meeting, Cole Oliver was granted approval to go on Windover Way, which is a local road, and he's got a business there, but he wants to come out on the local road. And those residents were here to say that they didn't think that was legal and it violates the comprehensive plan.
That didn't get approved, though.
It did. Did it not, Brad?
You're referring to rezoning, where Mr. Cole Oliver asked for the removal of conditions of a zoning ordinance on a property on Windover Way and Cheney Highway. And that was approved by City Council to remove the conditions of that rezoning ordinance. And the property was zoned commercial, regional commercial.
Still against the comp plan.
I will add, though, the findings from staff, the council concurred. They are the final arbiter of what is consistent with the comprehensive plan, and they determined that that request was consistent with the comprehensive plan. That's why it was approved by council.
We have a lot of respect for Brad. I believe that he was caught in a hard place here with zoning done by somebody else long ago. Nobody here anymore with that, and there was just a lot of conflict there. I think we really respect this guy a lot. He's got a tough job.
Thank you. Any other questions of Ms. Conklin? Thank you, ma'am.
Thanks.
Yes, sir. I believe you're up next.
Thank you. Again, Eric Page, Schutzen Bowen, representing the permit holder, Apollo Gardens. I just want to get on the record. I confirmed with Attorney Farrell, but still party status in this proceeding, correct? Okay. And I'm actually got a representative of my client with me here today who I'm going to bring up in a few minutes to speak a little bit. But I would like to just address first a couple of points. And first, rebutted a few things that Ms. Conklin said. The letters that I challenged were based on them being appropriate evidence for rehearing. I'm very sorry for her loss. I lost my mother in December. It's terrible. So I'm sorry. The Chapter 163 that we're seeing up there and that we're hearing about, that's different. This is a quasi-judicial proceeding in front of a board that is specific to the city of Titusville that follows those rules. A Chapter 163 proceeding used to go to circuit court. Now it goes to the Department of Administrative Hearings. I was in one last year. I was in one the year before. That's where they go. So what we're dealing with here is what does the common law say about how this proceeding is conducted and who has standing in this proceeding. And on that point, I did not misstate what was provided to this board. What was provided to this board in terms of that article from Mr. Severs, who made quite clear that he used to represent this board as a city attorney, was 5 pages of that article. I asked for it from the clerk. I got it today, and there's only 5 pages.
Excuse me, would you put down, we're not going to have displays in here. You can put it down, please. I'm not allowing displays while we have, until you are speaking. Please I'm asking you to place them down. You too, ma'am. I am requesting that you not put displays on. Then you may, ma'am, leave the property or leave the building if you're not going to comply. You have a choice. Officer. Hey, you can keep your sign up and we'll call you. You can come back, but I'm not going to allow you to stay in here with the sign. All right, we're going to take a 5-minute recess. There has been a correction. I've been informed that there is not a rule from holding signs, and therefore the lady that was asked to leave has returned. And I cannot, excuse me, sit down, please. Thank you. I wasn't finished speaking. So I apologize to you, ma'am. I made a misstatement, and I was informed there was no official rule set by the city at this time. So we will continue with your part, sir, please.
Thank you. I was asked to speak louder, so I apologize if I speak too loud for you. But some folks behind me, I guess, didn't hear me very well, so I'll try to do better. Addressing some of the points that Ms. Conklin raised, and forgive me, I don't recall exactly where we left off, so I may repeat just a tiny bit, but the article that was presented by Mr. Severs as part of his package only had 5 of those 15 pages of that article from my law school classmate and law review colleague, Christopher Donovan. The remainder of that article very clearly states what the appropriate standard is in regards to standing here. I'm going to let that article speak for itself. I'm not up here to argue standing anymore. I'm going to respect the decision of the board. I'm going to move forward. But I did want to clarify that point. I will object for the record. I'm not expecting a ruling on this, but for the sake of the record and potential appeal, I will object to the audiovisual display that was put up there. I don't think a foundation was laid for its admissibility. Don't know who took it, don't know when they took it, et cetera, et cetera. As well, the reference to the executed document from Peggy Busaka. It is actually the first page of tab 7 of the binder that I provided, and I pulled it out from the remainder of what is tab 7. That involved the application to the Florida Housing Finance Corporation, and part of that process required that my client, and it's page 103 of the full document behind tab 7. It's also just by itself the first page behind tab 7 because I try to make it easy. But at the time Ms. Busaka executed this, she was the community development director for the city. And this is a representation from the city's community development director that my client relied upon in pursuing its entitlements, both with the city and with the Florida Housing Finance Corporation. It's a very important point for us. And as well, your current community development director, Brad Parrish, has testified today that this building permit is in complete compliance with the comprehensive plan. And as I understand it, having party status, I'm allowed to cross-examine a witness. So I'd like approval to do that briefly.
The witness, I believe, would be Ms. Conklin.
No, it would be Mr. Parrish.
So that is a question for the board to allow him to ask Mr. Parrish questions. Typically, an applicant or a speaker can only address the board. So with your permission, he will have the permission to speak directly to the community development director as the expert who's provided the reports.
Is there any objection to him speaking? I see no.
I said I have no objection.
No objections. We have no objections, sir. Do I have to vote on that or just?
I think that consensus is fine.
Okay, thank you.
I appreciate it, and I'll be brief. Mr. Parrish, you heard the presentation of Ms. Conklin, correct?
Yes.
And what you presented earlier to the board was predominantly your January 29th, 2025 memo to the board as the community development director. Is that right?
Yes.
My question's pretty simple. Having heard Ms. Conklin's presentation, is anything that she said change your conclusions in your January 29th, 2025 memo to the board?
No. Our conclusion is the same. City Council determined the consistency of the land use and zoning on this property, and we are not in a position to reinterpret that, litigate what council has already determined. So we applied the comprehensive plan, the code, consistent with what the applicant submitted, and we reviewed it consistent with those regulations and those policies, and found that the application was consistent and issued the permit.
Thank you. I don't have any other questions for Mr. Parrish. I do have a couple other things to touch on before I bring up Ms. Berman. Basis for board decision-making, this is in resolution number 24-1997. I'm at 6.2 subpart B. The board must have before it competent substantial evidence to support its findings and judgment, which must also be in accord with the essential requirements of local, state, and federal law. And Part C states, the beginning of it, while the board should hear the objections of interested parties, the board's judgment must be based on the facts adduced and not on the mere polling of interested parties. And I believe that this board is going to follow the law. I believe that this board is going to look at whether or not it has competent substantial evidence. I believe that the law is very, very clear, and Mr. Parrish has stated it in his memo and has now restated it to this board, that this building permit that my client holds is in compliance with the comprehensive plan. This isn't a rezoning. This is an interpretation of whether it's compliant with the comprehensive plan. And the one person in this city who's designated with making that determination is Mr. Parrish, and he's made it, and he's just affirmed it twice, once when he presented and once when I cross-examined him. There's simply no basis to take away this permit based on a failure to comply or not be consistent with the comprehensive plan. If this board does that, it will be a taking. It will be a denial of my client's constitutional equal protection rights. And if it's done for the wrong reasons, it could be a violation of the Fair Housing Act. I don't want any of those things to happen. I want the permit to stand. I'm going to bring up Ms. Berman to introduce herself and to speak for a few minutes.
Stephanie Berman, 1398 Southwest 1st Street, Miami, Florida, 33135. Thank you for your time this evening and over the last couple of months. I know those seats are not easy seats to be in, especially on a night like tonight, and I thank you for your time. I am the president of Carrefour Supportive Housing. I would like to take a few moments to clear up misinformation that has been circulating regarding Carrefour and Apollo Gardens. Over the past 2 years, a false narrative has been created about who we are and what we have or have not done. I want to correct that misinformation. Carrefour Supportive Housing is a mission-driven, not-for-profit organization that builds affordable and supportive housing. We have served over 10,000 men, women, and children since we were created 35 years ago. Our team of over 150 includes social workers, case managers, and property management professionals, each committed to transforming lives through stable housing. Our residents are our mothers, fathers, sisters, brothers, and children who, for a variety of reasons, found themselves in need of affordable housing to support them in living meaningful, healthy lives. Our residents are also the hardworking men and women of this community who serve food at your favorite restaurants or the nurses' aides at your hospitals, but cannot afford skyrocketing rents. Our housing is not a treatment center, not an ALF, or a shelter. It is permanent multifamily housing where residents pay rent, sign annual leases, and are expected to abide by the leases they sign. Unfortunately, we have been the target of a sustained misinformation campaign. Carrefour has been portrayed as a greedy developer, even tonight you heard that, and our residents have been publicly described as dangerous criminals who wander the streets preying on widows and children. These portrayals are untrue and offensive. Much of the early opposition to Apollo Gardens, including from Appellant Vicki Conklin, focused not on land use or zoning, but on who would be living in the building. At a city council meeting in May of 2023, Ms. Conklin stated, "We have read a 132-page document submitted by Carrefour. That is where it described the kind of tenants that will be there. No criminal background checks would be done, so we kind of wonder, are there going to be sexual predators, burglars, thefts, and histories of assaults? We are fearful." She did not mention any concerns about Apollo Gardens' consistency with the city's comprehensive plan. Another resident said the following, "I am here to state my objection to the proposal to construct Apollo Gardens. Some very troubling unintended consequences could occur from having this marginalized population living next door to us. adults will be at liberty to wander through our community without supervision that could lead to public drug use and intoxication, drug dealing and drug overdoses, increased criminal activity, home invasions, and possible gun violence. Councilmember Moscoso said the following at the same meeting: Apollo Gardens will serve high utilizers, which she then goes on to describe in detail, and then says, as a mother of a kindergartner and a third grader, and a neighbor to many elderly neighbors and widows, this project is of great concern. Again, no mention of concerns regarding our consistency with the city's comprehensive plan. Resident after resident made similar comments at public hearings for many months. During these months, a website was created, a GoFundMe page was started where money was collected for an attorney. There were many social media posts and neighborhood meetings, all with the primary goal of stopping us from building Apollo Gardens, with a strong focus on who would be living in the building, not on whether the building and its use are legally permissible. The opposition was deeply rooted in classic not in my backyard sentiment. This fear-based rhetoric dominated the conversation for months until Carrefour raised concerns about potential violations of the Fair Housing Act. Only then did the website and social media posts disappear, and the opposition pivoted to the legal arguments about consistency with the city's comprehensive plan that they now claim support the appeal of our permit. Let me also clarify another important point. From the very beginning, Carrefour has communicated openly and frequently with city staff about Apollo Gardens. In 2022, we first approached the city about our plans to apply for funding to build Apollo Gardens. We were told in July of 2022, both verbally and via a signed certification, which you've seen tonight, from the city's community development director, that we had proper zoning and that our development was in compliance with the city's land use regulations. We had several conversations and email exchanges with the city in the months that followed. Then in January of 2023, before we purchased the land, we met with the city to again confirm compliance with zoning and land use regulations. And again, we received confirmation from the city that we were in compliance with zoning and land use regulations. Based on this confirmation from the city, we moved forward to purchase the site. We were transparent and have responded to all requests made by the city. Another misrepresentation is that Carrefour has not been responsive to neighborhood questions or concerns. During 2023 and 2024, Carrefour had many exchanges with neighbors, several of whom are in this room. We did our best to answer all the emails and questions we received. I have counted over 50 emails that I alone sent to neighbors in response to their questions about Carrefour and Apollo Gardens. We also invited a group of neighbors to meet with us to answer questions and listen to their concerns. We had a productive meeting and made several changes as a result of their requests, including removing a health clinic that we had envisioned in the building and saving trees that they told us were important to them. At the end of that meeting, one neighbor looked at me and said, "You do amazing work. Can't you just do it somewhere else?" This type of not in my backyard sentiment and the discriminatory statements that have accompanied it is the reason Carrefour has had to and will continue to defend itself and the people we serve with the Fair Housing Act, and are also the reason why we feel this board has no legitimate basis to reverse Carrefour's permit. I appreciate the opportunity to provide this background and to clear up any misinformation. Thank you.
Are there any questions of this witness? All right, seeing none. No, thank you very much.
Thank you. I won't be too much longer. Promise. Ms. Berman spoke about GoFundMe page and things along those lines. You will find in the materials that we presented an affidavit from Ms. Berman. It's behind tab 3. It states that she located those GoFundMe pages and other screenshots that she took indicate who was trying to raise money, who was opposing this project, and why. And what she said in terms of the why before there was a pivot to supposed challenges with the comprehensive plan is exactly right. And to further illustrate that, we have submitted behind tab 3 quotes from various speakers at 3 different public hearings. Those include Ms. Conklin, those include Councilmember Moscoso, those include other members of the public. I'm not going to read them, but I can tell you that they focus on the type of tenants. They focus on fear. They focus on crime. They focus on drug dealing. They focus on things that are not legitimate bases to say that a permit is not consistent with a comprehensive plan. That is the law. And they disclose what the real reasons are that a lot of people oppose this project. And those can't be legitimate reasons to oppose this project. So we've provided the videos. There are quotes behind that tab too. If you want to fact check me on the quotes, you're more than welcome to, but I can assure you that they are accurate. As well, if behind tab, I believe it is 5, forgive me if I'm incorrect about that, but it is the hearing transcript from the February 26th, 2025 hearing before the board. As you all know, we've had a court reporter at every one of these, and that again is a verbatim transcript certified by a court reporter of what transpired. That's the hearing where there was a 3-2 vote to deny Ms. Conklin standing. As soon as that 3-2 vote came through, y'all probably remember how the crowd reacted, and there was a recess. And that was the only thing on the agenda that day, was that appeal. So it then went up for public comment. If you want to read through that transcript, you'll see some really interesting comments. You'll see people literally saying the phrase, "not in my backyard." You'll see people talking about criminals. You'll see people talking about drugs. You'll see people talking about all of their fears. I get it, but it's not the law. It's consistent with the comprehensive plan. The permit is consistent with the comprehensive plan. You've heard that across the board. You've not heard anything from Ms. Conklin to dispute that it's consistent with the comprehensive plan. They talk about inconveniences. I understand. Garbage trucks are big. People park on both sides of the street. I get it. But the roads are what they are. The comprehensive plan is what it is, and this permit is appropriate. The other thing I'd like to point out that has been there all along, but I don't think it's really been noted. And this is in your packet today. It's page 16 of 245, and this is the actual handwritten appeal from Ms. Conklin. First line, proposed development is not a conventional MF development, multifamily development. Proposed development is not a conventional multifamily development. What's conventional mean? Well, Brad Parrish has told you there is nothing that is conventional or non-conventional regarding multifamily use in your city under the comprehensive plan. Conventional is folks don't want this there, not in my backyard. This is a legally permissible use. This is an absolute entitlement. Both of your community development directors have said that under zoning, under the comprehensive plan. It is a scenario where my client, if they do not get to go forward with this, they are having their equal rights violated. They are having their property taken. And I believe there would be grounds for a Fair Housing Act action. I don't want to do any of that. Just want the permit to stand. My client just wants the permit to stand. I appreciate your time. You've been very kind to me. You've been very understanding. You've let me speak at times that were unconventional, and you've considered arguments I've made, including today, that, weren't on the agenda. I really appreciate it. Thank you. And any questions?
I just want to make sure, did Ms. Berman fill out a card? Thank you.
She did.
Okay.
Hearing
I
none?
don't see any questions. Thank you very much. All right, we have some cards available, right?
Jill Sterling.
Please place your name and address for the record, please, ma'am.
Good evening, everyone. I'm Jill Sterling, 3514 Nelson Place. I've read about the Florida housing pilot in South Florida and the improved outcomes Carrefour and others have had for residents of their facilities, and I appreciate that greatly. I know it is important work. I've also read the application provided by Carrefour to the city that states, at least what I was provided just a few days ago, perhaps it has been changed. There will be on-site behavioral and health staff to support residents. The use of the facility in this capacity is beyond the R3 zoning description, at least from what I've found in Muni Code, that requires a conditional use permit in R3, which drives a planning and zoning board meeting, which I think City Council should have asked for many, many months ago. So I submitted a public records request today to ask the city to identify if they have or will request a conditional use permit, and if not, to provide rationale for the decision. There are 16 instances of the word treatment in Carrefour's application to the city, and the description provided in the application meets the description of a residential treatment facility. I'm not the Muni Code expert, but at least what I found, Chapter 28, Article 5, Division 2, Section 28-79, Standards for Conditional Uses, the Apollo Gardens facility is not even, it doesn't meet conditional use. It's not compatible with the surrounding neighborhood, and it exceeds what's stated as 45 units for the entire project. I'm all for, I think everyone here is all for the success of Carrefour and all their partners. It's just that I do feel that the fact that these two small streets, Ternessa and Demerit, are the only access for what may be, many support vehicles coming, at least, fire rescue, ambulance, police potentially. The South Florida pilot had numbers listed that were great as far as their success. The days residents spent in jail were reduced by 72%, but what about the other 28%? Arrests were reduced by 65%. What about the other 35%? So I think the residents along these two residential streets, it's been stated, not in my backyard. It's just not a suitable place for this type of facility that needs this type of support on residential streets. It's going to be an extreme hardship to the community, so that is why I decided to speak this evening. I do wish Carrefour and all their partners success, but I honestly don't know why and even why Florida Housing would continue to pursue this location. Just does not seem appropriate. Thank you very much.
Thank you. We have another card, please.
Dwight Severs.
Welcome.
Yes, sir. For the record, my name is Dwight Severs. My focus tonight is solely upon the law and the record in this proceeding. I certainly wasn't present at the February 26th meeting, and by the name, my name is Severs, not Severs. As shown on page 2 of the staff report, the comprehensive plan adopted in 1988 said, high-density residential use, such density shall be located adjacent to at least a minor arterial. According to staff's report, that was amended in 2007 to read high-density residential uses, and I would want my report and documents a part of the record. Such density shall be located adjacent to and at least a collector arterial street unless the property is located on the following local road, in the list, Rock Pit Road. I was the city attorney at that time in 2004, 2006, and conferred with the development director, and I was highly involved in drafting the comprehensive plan, reviewing and implementing parts of it. I worked with the development director, senior planner, Courtney Barkley, and then the city and council was approached by a not-for-profit entity, Housing for Homeless, who wanted to build housing for homeless veterans. Habitat Humanity owned property on Rock Pit Road, a local street, and working with them and Habitat Humanity and Housing for the Homeless, they had a multifamily existing unit there, and they wanted to expand that and build housing for the homeless. See Exhibit A attached, you'll see the location on Rock Pit Road, a local street. Because of the comprehensive plan did not allow high-density residential on a local street, and pursuant to Chapter 163-194, a development order could not be issued. The decision was made to amend the comprehensive plan to allow high-density residential on Rock Pit Road and Rock Pit Road only, a local street. This is how the project got built. Demare Drive and are local streets. It's not listed here in your comprehensive plan. In addition, Section 2712J of the LDRs provides in the event there's a conflict between these regulations and the comprehensive plan prevails. I provided a copy attached to the documents. The language of the high-density residential shall be located on at least a collector or arterial. Skipping on down, the comprehensive plan likewise does not define adjacent to, but your LDRs do. And interesting enough, adjacent parcel in question shall be located no more than 100 feet and easily accessible. I need a little bit more time to finish my report.
We have a copy of your report, sir. Do you need to read it word for word? Because it's multiple pages.
Well,
It's
it's
15,
only
20 pages.
the rest of this one page I'm on. The others are the documents. In addition, I'd like to respond to Mr. Page. You gave him additional time. You did not. He talked a great deal about me and standing, which wasn't the issue before you. That was the earlier issue. And I would like to simply say that
If you'd like to finish reading this, read it, sir, but let's not go on the other topics because witnesses, if I'm not mistaken, are not allowed to cross-examine. Is that correct?
I'm not asking to cross-examine anybody.
Well, you're commenting on his comment, sir. Would you finish reading what you were reading, please?
Sure. Based upon a review of the property appraiser's record and the recorded plat of Royal Oak property, Unit 3, the Apollo property is approximately 587 feet from the collector street. That's far in excess of being adjacent, as defined in the city code. Clearly, the code says what it says. To the extent that Apollo may have relied upon this certification by Peggy Pisaka, please look at it. It doesn't certify as to the comprehensive plan. It may certify as to zoning. If the applicant was, if the property owner wasn't smart enough to ask for that, shame on them. They should have asked for that certification. In addition, I attach for your consideration an excerpt dealing with variance, hardship. In particular, I would simply like to point to one section, and no, I have not included all the pages because they're not, some of them are not applicable. On page 8 of Exhibit D, it says all development orders, including variances, must be consistent with the duly adopted comprehensive policies, objectives, and goals under Florida Statutes 163.3215. This is not consistent with the plain language of your comprehensive plan. It's that simple.
Thank you, sir.
Thank you.
Next card, please.
Tony Schifolo.
Tony Schifolo, Tropic Street. I'm here tonight because I believe I have standing as a resident of Titusville to be concerned about multi-unit developments dumping onto local streets, because Tropic Street is a local street which the City of Titusville Planning Department through Mr. Parrish is trying to change the category so that what happens when streets are in different categories from local, then they're allowed to have multi-unit things. Setbacks are different. Right-of-ways are different. The whole plan for West Titusville, where Tropic Street is to turn it into something looking like Winter Park, according to Kimley Horn. So I feel that I have standing to speak about this because the comprehensive plan, which is the dream book for the town, says that multi-unit developments must be adjacent to arterial or collector streets. And that Little Demarest Street is definitely a local street, like Little Tropic Street is a little local street. And therefore, I don't know why this lawyer and Brad can say that it's consistent with the comprehensive plan, which says that multi-unit developments must be adjacent to arterial or collector streets. And one of the things that Ms. Conklin spoke of that you asked her about was that Windover. And yes, it's adjacent to a collector. It's adjacent to I-95 exit ramp. And you know that the DOT will not allow them to have access to an exit ramp from an interstate, but yet that is the adjacent to a collector road that allowed that developer to get the zoning changed. We're not even talking about zoning here. It's zoned multi-unit, okay, but it has no access to the type of road that it needs. And I don't know why we're standing around debating this. It's a very dangerous precedent to just willy-nilly ignore the fact that, oh, we're going to build more than 50 units that's going to dump onto this little local street when the comprehensive plan says that multi-units must be on collector and arterial streets. And you can see the reasoning behind that. Traffic, traffic, traffic. Thank you.
Next card, please.
William Appellant.
William Ballett, 2756 Demerit. As Vicki Conklin and Mr. Severs and others have so eloquently argued, the proposed site to build Apollo Gardens requires a clear and undeniable violation of the City of Titusville's comprehensive plan. And hopefully will be enough to convince the board to reject Carrefour's plan. On another note, I would like to respond to a previously stated suggestion that our community's objection to the Apollo Gardens site is somehow based upon a rejection of the Fair Housing Act. That could not be further from the truth. Every person I know who has worked so hard to preserve our community's current quality of life is an individual of compassion and integrity who rejects all prejudice and bigotry as ignorant, inexcusable, and morally reprehensible. We believe the mission to find homes for the homeless, mentally ill, and all others in need, regardless of race, color, creed, or religion, is a noble one and one we wholeheartedly support. As a former counselor of abused children and youth in trouble with the law, I know firsthand how deserving they are of assistance and firmly advocate that our government and society should care enough to adequately respond. However, the bottom line, unfortunately, is that Carrefour has chosen the wrong site to build. We reject the notion that it is necessary to harm one community in order to help another. It's really simple. Numerous concerns about the potential negative impact on our community have been previously stated. Rather than consider other available sites more appropriate for their project, Carrefour has stubbornly dug its heels in and refused to even look at other options. Another developer owning the land adjacent to Carrefour's had expressed an interest in possibly purchasing it from them. Rather than negotiate in good faith and consider selling the land for a reasonable price, Carrefour chose instead to inflate the price far above fair market value and preemptively reject any chance to make a deal. Just a couple more words. If Carrefour stands to lose any money.
Sir, we're going to cut you off.
Just
We
a
have-
couple minutes, it's just 2 minutes.
No, sir. No, sir. We have how many more cards tonight? We have many more cards and a lot of people to be hurt, sir. I'm stopping you now. Thank you very much.
I just ask you to
Thank you,
please
sir.
put yourselves in our shoes.
Please be seated,
Carefully
sir.
evaluate the merits of our case. Consideration.
Next card, please.
Mike Dwight.
Michael Dwyer, live on Demerit Street, across from this project. I have some issues with, one, the comprehensive plan, that it doesn't fit it for using a local road to use access to get to this facility. Two, you have a lot of seniors, young kids, and people that are older and just wouldn't be a good thing to do. I don't have a problem with them building, but not at this location. I think it's not the right place to do it, and just feel this needs consideration to be moved to another place and not be built on Demerit, off of Demerit Street. Thank you.
Thank you, sir.
Janet Davis.
My name is Janet Davis. I live at 1614 Ternessa Drive, which is at the corner of Demerit and Ternessa. So I am the,
Just a moment, just a clarification. You did sign a paper for Ms. Conklin to be your representative, but
I
do you
did.
still wish to talk anyway?
yes.
Very well. Continue.
Mine is the closest house to the proposed Apollo Gardens project. Their property abuts mine. All traffic going in and out will have to thread through the piece of demerit between my house and my neighbors across the street. For a bit of history, there was a proposed apartment project on this parcel. I think it was a one-story one. And I think in the 90s, the city denied it for the same reason we are opposing this one, access. I don't know the legal terms, so I'm not going to use any of those. I'd be out of my depth. Anyway, I remember Tom Mariani, who was either councilman or mayor at the time, coming to our house to tell us the city was going to deny that project. And one of my neighbors remembers Truman Scarborough coming to her house to tell them the city was going to deny the multifamily apartment project because there was not good enough access. I didn't know any of the words, but anyway. Two local streets, Demerit and Ternessa, which are the only routes to a more through street, are not nearly adequate to handle the additional traffic from both construction and normal functioning that Apollo Gardens will surely generate. Carrefour themselves have described their population that they plan to house as high utilizers, which I assume means high utilizers of services, which would generate extra traffic, it seems to me. These two small streets, Demerit and Ternessa, cannot handle all this extra traffic. They can barely handle the traffic they have now. Now, on an average day, Demerit is often difficult to navigate in a regular car because of parked and service vehicles. I think Carrefour made a mistake in choosing the location. They were probably so thrilled it didn't need zoning change that they failed to notice the negatives. Someone in the city council passed it. That person was gone from not from city council, city planning and zoning, who was gone before we even learned about the project. But they passed it through early on without looking carefully enough to see the negatives. Apparently, no one checked to notice these, or no one looked at the property and saw that it was a dead end. We, the residents, are asking this board to please correct these mistakes and to stop the development of Apollo Gardens at this location. Thank you.
Thank you. Next card.
Elizabeth Parker.
Ms. Parker?
Elizabeth Parker, 3446 Trevino Circle, back for a reprisal of my appearance. Quick comment, Florida statute drives the requirement for the city of Titusville to have a comprehensive plan. And further, Florida statute requires that we follow our comprehensive plan that we have created and submitted to the state for approval. So any argument that that is irrelevant to this proceeding is insane. That aside, this development is, as you know, seeking to access a 22-foot wide residential road. The comprehensive plan's transportation element protects our neighborhoods. Policy 1.1.1 demands safe access that minimizes residential impacts. This road is narrower than our city's average road, which is 24 to 26 feet. And we have driveways on both sides of this roadway. Residents face risks from both congestion and limited visibility, and risk in pedestrian traffic as well. Policy 1.1.3 requires high traffic uses like multifamily developments to access collector or arterial roads, not local roads. This plan violates that by overburdening this driveway-laden street. Policy 1.1.5 mandates a traffic study for significant traffic generators. I would like to point out that the traffic study submitted with this project cites roads that are not even close to adjacent to this property, and unless it's been changed, cites one road that's over by US 1. And in case anybody is curious, that's over a mile away from this project. So the traffic study itself is flawed. The applicant failed to disclose the purpose of this development, which is more institutional in nature than it is multifamily. I agree with a previous speaker. This, if it was going to go forward, should probably have a CUP. Anyway, future land use element policy 1.4.1 protects residential neighborhoods from excessive traffic. Policy 1.1.3 ensures compatibility with neighborhood traffic patterns. This plan is incompatible with a low-traffic residential single-family home neighborhood. Land development regulations, too, supposedly this is in compliance with them, but according to LDRs, this needs to have a 24-foot wide driveway on a 22-foot wide road. I don't know how we could be in compliance there. That's in section 30-152. We ask that the board deny the local road access and require a collector or arterial road access, reject their flawed traffic study, and consider the safety of this neighborhood. Thank you.
Thank you. Next card, please.
Carl Hanzig.
Carl Hansick, 1705 Harrison, number 147. I'm not a lawyer. I'm an engineer and a businessman. May I ask a question of Ms. Berman?
No, sir.
Okay, then I'll in form of a statement. Carrefour is getting funding for this from state dollars. But I'd like to know if they've ever created a project that exists today that is self-sustaining under its own tenants, or does it continue to be a draw? Follow the money. Years from now, somebody's going to be supporting this. And it won't be this fellow that's the lawyer over here. It'll be us. And we'll still be dealing with it because we've lived here. I've watched Titusville grow since I first moved here in 1989. This is one of the first times it's ever grown without it being tied directly to a space project. We have several examples in front of you, and most of us have seen the problems. We worry about service trucks getting through. Think about EMS vehicles. What's going to happen when there's a tragedy for one of these residents because EMS cannot get to them in a timely fashion? Titusville already has enough bad publicity going on. You all see the news. We don't need more of that. When that happens, I don't want to say, I told you so. I want you to have had the forethought and foresight to say, this is a bad idea that will lead to trouble, because human nature will prevail. And the bumper sticker is theologically correct. They use the S word, happens. It always does. I don't want to see anybody get hurt because we didn't have the foresight to see what everybody else will see and look back and go, what were they thinking? Thank you.
Next card.
Stan Johnston.
Stan Johnston, 860 Poinsettia Avenue. Thank you for allowing me to speak to you. I have two objections. One is the use, and the second is the threats. So I'm a professional engineer, and I've worked with Brevard County in land development, and I want to be recognized as an expert witness on these matters. And I believe I have standing because just like going over a bridge, and the bridge has got a fault that needs to be reported, I report it. So in this case, I've been the engineer of record of many subdivision site plans here in the city of Titusville, and I've run across some things like conditional use permit. And I believe there's some similar facilities that have people that are like the women's residential complex that may have several people in it that are maybe on drugs. And that what happens is that these are conditional use permits allowable. In this case, I want to question what has been said about non-conventional residential use. And I want to clarify that indeed, this is a non-conventional. None of my family will be able to reside here. None of the people in my Sunday school class will be able to reside here. Many people that I know will not be able to reside here. It's a special situation. In fact, is that I think it's a possibility that actually there are some communities would, I can't name them, but will have this as a hospital type of facility. It has special people there. So this acceptance by the city, Mr. Parrish and Mrs. Busaka is, I don't think is correct. I don't believe it's correct. And what you have listened to is Mrs. Davis talk about Truman Scarborough, Tom Mariani. There's City Attorney Severs. I believe he knows quite a bit more than Parrish and Busaka. In fact, I wanted to make a complaint about Mrs. Busaka, and there was no professional organizations that she's a member of that I could make a complaint to, although Parrish did have one. So she's on her own in many ways. This is a not conventional residential use. It is not conventional. And I'm explaining it to Mr. Page that way because, like I said, is there only certain people there. Whew, I don't have much time. Threats, $27 million? Going to people's elders and complaining about them? That's not very hospitable. $27 million? I just wouldn't want to work with people like that. As far as I'm talking about you being representing the city and the city being here. That's ugly. It's not called for, and I think you should not approve this project. Thank you. Here.
That's the last one on this item.
Okay, that's our last card at this point. Do we have anyone else wish to speak? Or is there any rebuttal? Yes, sir. Do you wish to rebut, ma'am?
Of course.
Okay.
I don't understand why he gets to rebut. It's our case, and it's against the city, but okay. So I want to thank you again for your time. Thank for everybody, the residents who come to support and let you know from them, it's not just me, it's from all of us. Again, it's a local residential road. It's a dead-end road. It's 22 feet wide. It violates the comprehensive plan for this project to develop right there. Sister facilities of that particular project had 436 emergency calls in the first year. And so we foresee that's a lot of extra traffic on Demerit in addition to what it's currently encountering. So it's not capable of handling that excess traffic that's generated. It's not an arterial, it's not a collector, it's far away from an arterial collector. Adjacency is not equal to access. So just because the collector road and the arterial road of Barna and Harrison are adjacent, it's not the same thing as being right there for access. The comprehensive plan requires access, and it states that very, very clearly. So this is a very obvious violation of our comprehensive plan, as well as the Florida statutes 163, which is very applicable to this, Mr. Page. The BAA must rule to uphold this appeal and to avoid placing the city in legal jeopardy. This is not about the merits of the affected project. It is about adhering to the rule of law, the comprehensive plan, and it's about the adverse effects to a neighborhood whose residents believe that they have a right to the protection of the city for the comprehensive plan.
Thank you. I don't know whose this is. I don't want to take it. Is that somebody's? Is it yours? Eric Page again on behalf of permit holder Apollo Gardens. I'm going to be relatively brief. Heard a lot of comments there that have nothing to do with the appeal. The appeal is what's in the appeal. It's the three comprehensive plan provisions that Ms. Conklin say are not consistent with this development permit. And you've heard from Brad Parrish, both in writing and in this presentation and on cross-examination, that this permit is consistent with those comprehensive plan provisions. And that's the only issue here today. I would like to address a couple of points that were raised from the perspective of asking Mr. Parrish his opinion on those. So I would again ask for the indulgence of the board to let me do that. It will be just a couple of quick questions.
Just a couple of questions, and that's all, please. Don't.
Mr. Parrish, there is a comment made that this site is only zoned to have 45 units on it. Is that correct?
The site is zoned to have 15 units per acre, so the proposed site plan with, I believe, 84 units is consistent with that.
Okay. And the only other question, and I apologize if I pronounce it incorrectly, Mr. Severs.
Severs.
Thank you. Mr. Severs provided some testimony, and he as well provided a report. Have you reviewed that? Or at least listened to his presentation?
I did.
Any of the information that he provided change your position in terms of your written report to the board or what you've spoken to the board about today?
No, Mr. Severs was referring to an amendment, which I already described in my report, to that particular policy that's most relevant to this case, and that is the locational criteria. But our position is that that is locational criteria that was added in there for requests to put a land use on a piece of property. This property has been designated with this land use for several decades by council, so they made a determination that it's consistent. Staff is not in a position to reinterpret that.
And just speaking to some of the comments made, comments like, don't know why my client wants to pursue this location. Well, my client was told this location was suitable for its use, and they have every right to do so. There were comments made from some folks who are quoted behind tab 2, and the quotes from those prior public hearings are very clear that their issues with this project have nothing to do with the comprehensive plan. They have to do with fear of drugs or violence or crime. I'm not going to quote those folks and read it, but they are behind tab 2, and the videos have been provided if you want to check the accuracy of those. Statement was made, Carrefour has chosen the wrong site to build, but again, it's their legal entitlement. There was a lot of comments about another location and other issues in other places. None of that's competent, substantial evidence.
I'm sorry, with audience, you're going to have to be quiet while he's speaking, please. Thank you.
A comment I wrote down was that my client failed to disclose the purpose of this development, and yet we've got folks coming up here that are quoting from their disclosure that, or from their application that included all of these disclosures. So it's kind of like we can't win here. My client did at all points in time disclose to the city and to the state authorities what it was that they wanted to do, and it was approved across the board. I wrote down this quote, "This is a bad idea that will lead to trouble because human nature will prevail." That has nothing to do with the comp plan. I'm sorry, it does not. If Mr. Stan Johnston is going to be accepted by this board as an expert, I would request the opportunity to voir dire him on his qualifications to be an expert on this subject. So I would ask, is the board going to consider him an expert?
That was his comment, sir. We did not take an action on that.
Thank you. It was stated that what my client wants to do is a non-conventional residential use. You do not have conventional versus non-conventional in your code. It doesn't exist. The tenants were also called special people. I don't know what that means, but it certainly doesn't have anything to do with the comprehensive plan. The last thing, as a point of order, there was a motion submitted that I discussed a little bit previously about revoking the decision on the motion for reconsideration and denying the motion for rehearing. There also was a pending motion for rehearing at the last hearing. I'm quite certain what the outcome is going to be, but for preservation issues, I would appreciate if the board would please take a roll call vote on those two motions so the record is clear as to their disposition. And I would ask Attorney Farrell to counsel the board in that regard, but I believe you understand what I'm asking for, and I'm happy to clarify it if you don't.
So what I'm hearing you ask for is the board to entertain your two different motions, the one that is in tab 1.
I'm asking that they entertain that and just do a roll call vote on it, so there's a final determination.
Right.
And I'm
then
asking that
the other
they...
one also being the vote on, could you just articulate
Yes,
what
and
the
I'm
two
asking
motions
that
are?
they do a roll call vote on the motion for rehearing that was never called up for a vote at the last hearing. And I ask that because if I don't ask that, I'm afraid I haven't preserved an issue. So I'm not trying to drag this out. I know what the outcome's going to be. I just need it in the record, or I need to at least have asked for it and been denied that opportunity.
Did we not do a roll call vote last meeting?
You did one on the motion for reconsideration, but not on the motion for rehearing that had been on the agenda and noticed.
I do believe that that would be a moot point since the agenda item was brought back up, but it would, you have the right to ask the board whether they would like to entertain that motion, which you have just done. It's up to the board to decide if one of the board members will make those two motions that Mr. Page has asked for.
And if your legal counsel has determined that a ruling on those from the board would be moot, and that's the legal position of the city, then in my opinion, you don't have to vote. So, but I would ask for one or the other. Either they're from legal counsel, they're declared moot, or I would ask for a roll call vote on those two motions.
I do believe that the motion for rehearing is moot, having had the motion for reconsideration and bringing the appeal back up before the board this evening. And I do believe that I've also advised this board that the motion for reconsideration was appropriate based on the precedent and the prior history of this board and other boards allowing a motion for reconsideration at subsequent hearings, because you do not have consecutive board meetings one day after another, and I do not believe that rule applies for this board.
And as to the motion for rehearing, is that rendered moot in your legal opinion?
Yes.
I appreciate it. I have nothing further. Happy to answer questions.
I see no questions.
Thank you. Appreciate it.
Okay, at this time, we'll close the public hearing and bring it back to this board to discuss. And I have one comment that was made earlier about precedents of the city council is doing things. And I wish the city council, well, I'm just saying I wish, excuse me. I see the city council as the one that makes the rules. You're asking us to interpret what staff and our own lawyers have decided or have come up with, that this is a permitted event. If you feel that things are wrong in the city code, I would suggest you have city council adjust the code. We are not elected here. We are volunteers. We are professionals in our different fields. But to have us come up and set precedent and make rules that will account, I think that's the city council's job, is my personal opinion. And I feel that we would be doing that if we started to set this precedent. That is my thoughts. Any other thoughts? All right, I see no other calls or anybody to speak. Do I have a motion on this matter?
My motion is to agree to the appeal, number 1-2024 Apollo Gardens Site Development Permit. Approve the motion.
All right. Do I have a second?
Could you just clarify?
Clarify the motion.
Motion is to agree with the appeal, number 1-2024 Apollo Gardens Site Development Permit repeal.
Just a moment, please. Is that correct wording, Counselor?
He is making a motion to agree with the appeal that was filed by Ms. Conklin. Is there any additional basis that you'd like to provide?
No.
I have a question.
Yes, sir.
There are three particular policies that are being appealed, basically. Is the appeal motion that you're making related to all three together or individually?
Don't understand your question, Brad.
The applicant in the application stated,
Yeah, give us a page number, please.
page 16 of your application, of the packet,
68?
16.
16.
Grounds for appeal. This is what the appellant stated. Proposed development is not a conventional multifamily development and is not consistent with strategy 1.13.11 and policies 1.14.5 and 1.14.16, which should say 6, of Titusville Comprehensive Plan. Is your motion related to all of that together or each part individually?
Specifically, 1.14.16 of the Titusville Comprehensive Plan.
You said that was 6, not 1.6.
I'm reading off the page.
Yeah, no, he said that was incorrect. Is that correct? You said it's 6, not 1.6.
Correct. The correct policy is 1.14.6.
Correct.
So your motion is only related to that particular policy and not the others, that other statements that were stated in the appellant's application.
Yes.
Is there a second? Not hearing a second. Is there another motion to be made? Counselor, what happens if there's no motion? For or against?
Well, then I would presume you guys have discussion to help you come to a decision. This board does require 4 votes to overturn the decision of an administrative official, so to grant the appeal requires 4 votes of this board.
Well, let me try it again. Motion to accept all 3 components of the appeal. Of appeal number 1-2024 Apollo Gardens Site Development Permit. Will broaden the horizon.
I have a question. On the application, again, page 16, you said all 3 parts. Are you referring to all 3, the strategy and the 2 policies? Because there's also the statement that this is not a conventional multifamily development.
I'm reading the appellate's all 3 proposed components. The proposed development is not a conventional multifamily development and is not consistent with the strategy 1.13.11 and policies 1.14.5 and 1.146 of the Titusville Comprehensive Plan.
Your motion includes everything that's stated here on grounds for appeal on the application on page 16.
Yes, indeed it does.
I've had another motion. Do I have a second or discussion? You won't.
Just wondering. I can't hear you. I'm just wondering what the difficulty is in all of us being able to come up with a decision.
Haven't had a second yet.
Oh, for discussion?
In order for the board to continue to talk after a motion's made, there needs to be a second for discussion so that somebody is seconding the motion, or you just wait for the motion to die for lack of a second.
Anybody want to have a discussion?
All right.
Motion for discussion?
No, you have to
Second
second
for
first.
discussion.
Okay, a second for discussion.
You're seconding again?
Yeah.
Okay, we have a second. Now we can discuss. I've given my opinion. Do we have any other opinions to share?
Well, if we take each one of the items in the grounds for appeal, we can look at them individually. Sorry about that. I said if we take each of the aspects of the grounds for appeal from the application, we can start with the proposed development is not a conventional multifamily development. Given the testimony of Mr. Parrish, we understand that there is no such thing as a non-conventional multifamily. Can we agree on that?
I agree. There's no such thing as unconventional or conventional.
Any disagreement? No, everybody agrees on that, yes.
Let's move on to the second item. Strategy 1.13.11 was not applicable, according to Mr. Parrish, and also policy 1.14.5 was inapplicable.
I agree with that.
Are we all on the same page for that? Okay. The last item is 1.14.16.
Or 6.
It's actually 0.6.
Yeah, 0.6.
Addressing the Titusville Comprehensive Plan. And we've heard Mr. Taylor's opinion on that. I tend to agree with him that council sets precedents, they set the rules, they determined that the zoning was applicable for the comprehensive plan and have done it actually several times over the decades, and I can't see us changing that. With that being said, I move to deny the appeal.
You can't do that until there's a vote on the motion. I'm sorry, there's a motion on the table that you guys are discussing, and there needs to be a roll call vote before you can make another motion.
My mistake.
Currently, that motion includes all 4 aspects of that grounds for appeal, which you have just stated that the first 3 parts are not relevant. At least that's what I understand you said.
That's correct. If there's no other discussion here, we'll take a roll call on the motion. And it will take a 4 vote to approve. May we have roll call, please?
Vice Chairwoman Van Deven,
I don't agree with the motion.
So, no.
No.
Member Beckles,
No.
Member Green,
Obviously, yes.
Member Wheelis. No. Chairman Taylor.
No. So the motion has failed. Okay, so is that not it? Or
Member Wheelis, now you can make a motion if you'd like to. So the effect of, unless the board would like to just accept that the motion to grant the appeal failing being the end of the item, and that's fine.
That's fine.
All right, that's it. Okay, this is over with then, right?
Yes.
Okay. Thank you. We're going to take a 5-minute recess at this time. All right, where am I? I'm on page, who knows? What page am I on? We're back to the first. Yeah, yeah, but where is it? Okay. Where is it on the pile? What was? Okay, everybody here now? Good. Okay, we'll call this meeting back to order. Now we're going back to new items, and I believe the first one up is variance number 7-2025 for 702 Lucky Street. Is that correct, staff?
Yes, sir.
All right, would you continue with us, please?
Yes, sir. Variance number 7-2025 for 702 Lucky Street, beginning on page 126 of your packet.
Yes, ma'am.
This variance request is for Land Development Regulations, Chapter 28, Section 28-305, single-family high density, to allow less than the required 20-foot side corner yard setback for a primary structure for property located in the single-family high density R1C zoning district, located at 702 Lucky Street, as submitted by Jeremiah Ofori, registered agent for Gold Coast Developers of Florida LLC, owner. Should I read the powers of the BAA again for the criteria for the variance? Thank you.
Does anyone want to hear that?
Okay.
We had it already once.
I know it's
Thank
been a
you.
bit, so want to make sure. The applicant is requesting a variance to the Land Development Regulations, Chapter 28, to allow the construction of a single-family residence with a side corner yard setback of 10 feet instead of the required minimum of 20 feet. The subject property is a non-conforming 5,000 square foot corner lot with 50 feet of frontage along Lucky Street and 100 feet of frontage along Second Avenue. These dimensions do not meet the minimum 6,500 square foot lot area and 65-foot lot width outlined in the single-family high-density R1C zoning district standards. The surrounding area is primarily composed of single-family homes and vacant residential parcels, many of which share similar dimensions and configurations with the subject property. The lot was originally platted as part of the Reed and Allen subdivision in 1913, well before the administrative rezoning in 1993 that established the current dimensional requirements for the development of the site. The applicant has indicated that the narrow width of the corner lot creates a constraint in meeting the required 20-foot side corner yard setback. Although a detailed concept plan has not been provided, if the variance is approved, all remaining setbacks will need to comply with the dimensional standards of the R1C zoning district in accordance with LDR Section 28-305C. Given the non-conforming width of the lot and its corner location, these conditions may constitute a hardship that supports the request for a reduced side corner yard setback. The staff recommend approval of the variance to allow a single-family residence to be constructed with a side corner yard setback of 10 feet instead of the required minimum of 20 feet. In granting the variance, special conditions and circumstances do not result from the actions of the applicant. The reduced lot width presents a hardship to the applicant, and granting the requested variance will not confer upon the applicant any special privilege that is denied by ordinance to other lands, buildings, or structures in the same zoning district. The plot plan showing the setback request is shown on page 175 of your packet, if you'd like to look at that. And with that concludes the staff report, and I'm available for any questions you may have.
Okay, does anybody have any? Okay, because this was, like you said earlier, this was plotted way back before all the rules changed
Yes,
for
sir,
setbacks and
1913.
everything. All right. No other? Seeing no questions, staff, do we have any cards on this?
No, sir.
All right. Then we'll close the public hearing part. Had you had any contact with the applicant saying they would or would not be here for this?
No, I had not. I believe he is here.
Oh,
He's here.
what?
I don't have a card for him.
Did you want to speak to this, sir? That you would want to do this, or what? I do want to do this. Well, have you not heard me say to fill out a card so that you can be called up for different events or to talk? We would like to hear your thoughts on this, why you want to do this, sir.
I filled out an application that said my piece, but I will.
Yes, well, that's part of our hearing process. If you would, just fill this out after you talk, please, sir.
You can speak first and then
Just
fill it
speak
out after.
first and then fill out the card. Thank you very much. Your name and address for the record, please, sir.
My name is Jeremiah Ofori. Address.
Wait a minute. Okay, now it's on. Thank you.
Jeremiah Ofori, Gold Coast, address 852 Old Berry Hoover Road. This is a non-conforming lot that has been back since 1913. We plan on building a single-family home on it. We are taking in some of the infill lots throughout the city and trying to build single-family residential homes on them. And this is one of the ones that we came in contact with. Currently, the non-conforming lot, if we go by the 20-foot setback, would not allow a conventional standard house to be built. So requesting the 20-foot, the 10-foot instead of the 20-foot would allow us to put in a normal spec home, is what we call them. Okay.
Very good, sir. So this is not your first property to do on a non-conforming lot?
No, sir. I think we're up to about 26 right now throughout the city.
Wonderful. Any other questions from anybody here? I assume you're having success because you keep building more. You're selling them.
Not all of them we're selling. We're renting some of them.
But it
yeah,
is, you mean,
there is some
using
success.
housing. Yes.
Yep.
All right, sir. Any questions? Anyone else?
I have
Yes, sir.
one. How large is the house going on the lot?
It's going to be 1,700 square feet.
Okay.
And so roughly 59 by 29.
I see. And the setbacks of the existing homes around it are setback 10 feet?
Yes.
Or, okay. All right.
This home fits the neighborhood and the criteria. This is just only because it's a corner lot as we're asking for this variance. All the other lots nearby.
We understand. Thank you.
All right.
All right, sir. Thank you very much for coming up. And
No
if you would fill that out and give it to the secretary, please, sir. All right. You said there's no other cards, right?
That's correct.
Okay, so we'll close the public hearing. Is there any discussion or questions of staff from anyone here? I see none. Do I have a motion, please?
I move to approve the request for variance.
It's 7-2025.
For variance 7/20/25, 702 Lucky Street.
Second.
All right, we have a motion and a second. Any other further discussion? Not seeing any. Maybe I have roll call, please.
Member Green?
Yes.
Member Wheelis?
Yes?
Chairman Taylor?
Yes?
Vice Chairwoman Van Deven?
Yes?
Member Beckles?
Yes.
Congratulations, sir. You've been approved. All right, now we move on to, gotta get past these others. What's the page number for our next one?
Page 190 for variance 10-2025.
190, right?
190, yes, sir.
Uh-huh, okay. Okay, so this is, here we go. Yeah, 10, variance number 10-2025, 3041. And isn't the next, kind of the next one also the same issue?
Yes, they are neighboring properties.
They are neighboring. would it be acceptable to this board that we discuss the merits for both of these items at one time, but we will vote separately on them?
Good idea.
Very good. All right, would you lead us off, please?
So just for my clarification, read the staff report for 10-2025 and then move on to 11-2025 for you then to discuss them both?
Yes, because I believe that they should be identical as far as.
It's different applicants, but the same.
Different applicants,
set
but
request.
yeah, we're looking at the
So
request
there's
stuff.
slightly different. Okay, I
Thank
will
you.
move forward. Thank you. For variance 10-2025 for 34-1 Eddington Drive, the request is for land development regulations, chapter 30, section 30-321, plant materials, to allow the use of prohibited material in the form of artificial turf for property located in the single-family medium-density zoning district at 3041 Eddington Drive, as submitted by Matthew Boffo and Maggie Boffo, trustees for Matthew S. and Maggie R. Boffo Trust, owners. The applicant is requesting a variance to allow the use of artificial grass in place of the natural grass. Section 30-321F of the Land Development Regulations states synthetic plants prohibited. Synthetic or artificial material in the form of trees, shrubs, ground covers, vines, or artificial turf, shall not be used in lieu of the plant requirements in this section. The Brevard County Property Appraiser website shows the single-family dwelling was built in 2021 as part of the Country Club Estates subdivision. The lot contains a 10-foot public utility easement along the front, a 5-foot public utility and drainage easement along the sides, and a 10-foot public utility and drainage along the rear. As shown on the submitted site plan on page 197 of your packet, the owner is requesting to place the turf in the front and rear yard. The property is not located within the area of critical concern and does not have a maximum impervious coverage standard. Since there are no code standards for artificial turf, staff cannot evaluate its impact on the subdivision's approved stormwater plan. The lot does not appear to have any special conditions or circumstances that are peculiar to the land that would create a hardship that would prevent natural landscaping. Staff recommend denial of the variance. There are no special conditions or circumstances which are peculiar to the land which would make it different from similar lots in the subdivision. The applicant can meet the literal interpretation of the ordinance, and denying the request will not deprive the applicant of rights commonly enjoyed by other properties. Now for variance 11-2025 at 3042 Eddington Drive, the request is to the same land development section, 30-321 plant materials, to allow the use of prohibited material in the form of artificial turf at 3042 Eddington Drive as submitted by Michael Boffo, trustee for the Michael A. and Nancy M. Boffo Trust, owners. The applicant is requesting a variance to allow the use of artificial grass in place of natural grass. And the section 31-321 states again, synthetic plants are prohibited. Synthetic or artificial material in the form of trees, shrubs, or ground covers, vines, or artificial turf shall not be used in lieu of the plant requirements of this section. Brevard County Property Appraiser website shows the single-family dwelling was built in 2020 as part of the Country Club's Estates subdivision. The lot contains a 10-foot public utility easement along the front, a 5-foot public utility and drainage easement on the sides, and a 10-foot public utility and drainage on the rear. As shown on the submitted site plan for variance 11, which is on page 232 of your packet, the owner is requesting to place the turf in the front and rear on only one side of the property. The property is not located within the area of critical concern and does not have a maximum impervious coverage standard. Since there are no code standards for artificial turf, staff cannot evaluate its impact on the subdivision's approved stormwater plan. Staff recommend denial of the variance. There are no special conditions or circumstances which are peculiar to the land that would make it different from similar lots in the subdivision, and the applicant can meet the literal interpretation of the ordinance. Denying the request will not approve the applicant of rights commonly enjoyed by other properties. And with that, that's the staff report for both variance 10 and variance 11, and I'm welcome to take any questions you may have.
All right, let's call up any questions of staff on this before we go to a public hearing? Yes.
We've recently discussed this same issue with a couple of other properties on Eddington. Has anything changed in the ordinances related to, or LDRs related to use of artificial grass?
No, they were, the council had the one, they were looking into amending for the turf ordinance that has since been stopped because of the potential Florida statute that is in consideration right now at the House to allow installation of synthetic turf in single-family residential areas and to where the bill would prohibit local governments from adopting or enforcing any ordinance that prohibits or is used to prohibit it. So, and staff have kind of stopped working on that ordinance and waiting to see what the.
Did you get today's
House would be.
update? I didn't have a chance to talk with you. As of today, the House voted unanimous approval of that bill, so it'll be sent to the governor. And what the bill does is it prohibits local governments like the city of Titusville from prohibiting any synthetic turf with any or disallowing anything that meets the state's regulations that will be set by rules set by DEP. Those rules have yet to be set, of course, and this is all contingent upon the governor signing this bill.
Yes. So the DEP will need to create standards for evaluation of turf, and then as long as the synthetic turf meets those standards that are created by the DEP, local government will not be allowed to prohibit the use in single-family zoning should they meet those standards. Again, as council stated, if the governor signs that bill, but it was, I guess, passed through the House today.
Where would that leave us denying the request?
I believe that you have the ability to approve or deny the variance as was presented to you. I think that the potential change in legislation would provide for different avenues for the property owner going forward, depending on the outcome.
So the property owner would still have the ability to appeal if, once that new decision is, no?
They wouldn't have to appeal if it.
They wouldn't have to appeal. It'll be law.
Correct.
If the
But
law
if we deny it, we
changes,
deny it.
if the law changes, then it would be a changed set of regulations, where I think that at that point in time, the city would not be able to prohibit.
Okay,
Correct.
all right, got it, thank you.
Okay.
Additional question for staff.
Yes.
Are the owners under any kind of code enforcement action because of this?
Yes, I do believe so, but they can speak to that more. And they have paused for the hearing. I'm unsure, depending on if the denial was, what that would do for the code enforcement.
Are there any homeowners here tonight?
I have not met them in person, so I'm unsure,
Okay.
but.
All right, thank you.
I've talked to them on the phone.
Okay, so we'll open it up to the public hearing then to answer any questions. All right, so we have.
So it's the
first-
public hearing for the first one, variance
Yes.
number 10.
Yes. No. And whose card should for that, please?
Matthew Buffo?
Welcome, sir. If you please give your name and address for the record.
Good evening. Matthew Boffo, 3041 Eddington Drive. And I guess before I start, just so it's very clear, this turf has been down for nearly 2.5 years. And I'll explain through what I'm going to state. So depending on what the outcome of it is, there would be other avenues that we could take. With that, first, thank you to the Board of Adjustment and Appeals for the opportunity to speak today. We're not here simply to request approvals for a variance, but also to explain why our decision to install a permittable artificial turf was a thoughtful, responsible, and environmentally conscious choice. We want to begin by respectively acknowledging that we are unaware of any city code prohibiting artificial turf in resident landscaping. We did not intentionally violate any ordinance. In fact, we consulted with 3 professional landscape companies, all of which included artificial turf as part of their recommended solutions. The project began as a small putting area in the backyard for our children, which involved a border turf installed due to our growing appreciation for the functionality and aesthetic value. At no point did any contractor suggest that the municipality review was required, as this type of landscape project typically does not require any permitting. In response to ongoing issues with our yard, including poor builder grades, substandard landscaping and irrigation, low water pressure issues, sandy soil, erosion, and inadequate drainage, we made the most informed and responsible decision available to us at that time. We selected a professionally installed, PFAS-free, lead-free, UV-stable turf system that was permeable and drainage conscious. We continue to use our existing irrigation system now with upgrades to support exterior planters and Florida-native landscape. Our yard is maintained entirely without unnecessary chemicals, aligning with Florida's friendly landscaping principles. This request is not just about correcting a misunderstanding, it's about seeking approval to continued support of a sustainable, well-maintained, and beautiful property that contributes positively to our home, our neighborhood, and the beauty of our city. I'd like to point out some other items through this process that we went through within our review. This was a very costly project that we looked at from every avenue. I was born here, I left, we come back to raise a family. I'm very well aware of all the issues surrounding water runoff, tons of chemicals, everything that the city has faced for, 40, 50, 60 years. Permeable turf improves drainage and reduces erosion. The installation of crushed stone drainage base, which ours is, the turf allows water to filtrate through instead of pooling or running off. It resolves previous issues with standing water, supports healthy soil, and prevents erosion. This design reduces stress on the city's stormwater infrastructure and improves sustainability at all residence levels. Artificial turf reduces pollution overall. No mowing means lower carbon emissions and noise pollution, no need for pesticides, herbicides, or fertilizers, zero chemical runoff into our storm drain and waterways. The yard includes Florida native plants, planters, and pollen-friendly features that support a biodiverse aligning with the city and state's goals. We created a low-maintenance, green, and sustainable landscape without sacrificing aesthetics or functionality. Artificial turf is often blamed for microplastic pollution. However, high-quality UV-stable turf fibers, especially in residential settings, rarely degrade or mitigate this measurable quantities. According to Dr. Chris Diarmit, a global recognized PhD polymer chemist and founder of phantomplastics.com, which is a great site to go to, there is no scientific evidence that microplastics at the environment's realistically levels causes harms to human or the ecosystem. Most alarming microplastic studies are based on unrealistic laboratory conditions, not real-world scenarios. Dr. Diarmit has over 20 years of experience, holds multiple patents, and has consulted on major global companies like Apple, Lego, HP, and P&G. He is peer-reviewed research whose work is grounded in the field, not media narratives. His mission is to replace fear-driven misinformation with evidence-based understanding. He clearly states microplastics fears are largely unsustainable by scientific evidence. Our turf is made from UV-stable polyethylene, a product that is safe in food packaging, water systems, and medical devices. It is chemically inert, meaning that it does not react to water, soil, or sunlight in any way that causes harm. UV stabilizers added to the turf protections to break down and extends its lifespan, minimizing any potential for fiber release. Dr. Diarmit affirms that UV-stable polyethylene is not a forever material. It can degrade over time in a controlled, predictable manner, unlike many fertilizers or chemical lawn treatments. Compared to traditional lawn care practices, polyethylene turf has a low environmental impact in terms of emissions, water use, and chemical exposure. In closing, our request is not to minimally need a resolve to protect our investment. We are not requesting a change to zoning or seeking special treatment. Rather, we are asking for a modest exemption to accommodate what is already installed. We acted responsibly and in good faith, making decisions based on professional recommendations that were environmentally sound practices. Our turf installation was not a shortcut, but a very carefully planned upgrade that addressed long-standing issues with sustainability, attractiveness, and load impact means. We are part of a neighborhood where most of the residents take pride in their homes. Our decision reflects those same values: beauty, property values, and long-term care. We believe homeowners deserve smart, sustainable choices. In addition to traditional options, especially those where choices reduce water usage, avoid chemical exposures to our water pollution, and promotes biodiversity. This variance supports individual responsibilities, environmental alignment, and community standards, not an avoidance of code or accountability. We respectfully ask that the board to consider our circumstances, our proactive choices, and the clear commitment to our city. Approving this variance is not just a fair resolution, it's a win-win for our home, our neighborhood, and the city of Titusville.
I have a question.
Sure.
You mentioned that polyethylene. But
Correct.
on page 214, from the, I guess where the installers of this, let's see, it's key features of VistaPet.
Mm-hmm.
It says it's actually polypropylene, which is harmful. And that's what it says strong woven polypropylene base, and then non-woven polypropylene middle layer. Polypropylene is known to cause microplastic pollution. And I wanted to ask you, how long from the installers did you were given for this turf to last? 16 years? I'm looking at the actual flyer that was submitted. And after 16 years, you're going to tear this up, and it's going to go into a landfill, and it's non-biodegradable, which means it's going to sit there for years and years and years. Those are some of the things that we have to consider. So I know that I've heard that polyethylene is a little less harmful, but what you're proposing is polypropylene.
Both polypropylene and polyethylene, are plastic bases just like PET.
But the polypropylene is worse. I mean, if you go to any site on the internet, you put that in versus the polyethylene. And I know that some of the woven features of yours do have the polyethylene according to the flyer.
Correct.
But it has more polypropylene than anything else. So that's where the concern is. We all need to educate ourselves the difference in, what the turf is made of, but in this particular instance, what you provided shows it could be a danger to the environment. I didn't hear you mention polypropylene, only polyethylene. And polypropylene is the major component of this. And that.
It's a mixed component just like many other components in plastic.
Excuse me?
It's a mixed component like many other components in plastic. So I am actually in the packaging industry.
Right.
I deal with PET, PE, PP, all of that.
Right.
To say that one is more harmful than the other, you're discussing really a narrative based on what additives have been placed.
I'm a layman. I'm only reading, what's in this, and then I'm just did a little bit some research. I mean, as a layman on the internet, and I know everywhere that I looked, it listed all these different things. I'm only referring to polypropylene.
And I would highly recommend that you go to phantomplastics.com. He is a leader in the plastics industry based on narratives that are being discussed of what is harmful, what is not harmful, especially when we're talking about forever chemicals, the breakdown of microplastics. You're talking about parts per million, parts per billion.
Is it biodegradable, this turf?
Everything is biodegradable based on time span. I don't know specifically what that's going to take, nor does anyone else. You could look at a Publix shopping bag, right, which is a PE material. It has less additives put into it. It can biodegrade in about 9 months. It depends on how it's put together. I'm not a scientist that's going to break down
And I'm just a
and tell
layman,
you
so
that.
I'm only reading, what the ingredients are.
Understand.
Where it came from, where the lifespan of it is. So maybe some other people who are a little bit more knowledgeable might have some more information. But from what I know, it's harmful. That's just myself.
I would beg to differ.
Thank you.
It's harmful not just because of the materials, but it also interferes with the evaporation precipitation process. It's terrible for wildlife, all of that. So it's not just the materials, but it's just bad. There are other alternatives. If you had a good landscaper, they can come up with better alternatives than artificial turf. That's all I have to say.
But why would the state then be recommending it?
I can't speak for the state. I can only speak for what my knowledge base is.
Are there any other questions of this witness? Thank you very much.
Thank you.
Do we have any other cards?
Maggie Buffo?
Okay.
All right, he has spoke for you. Is there another card?
Tony Schifolo.
Tony Schifolo, the historic Norwood House. This may be a moot point now with what the state, but the state legislature hates the residents of Florida, especially if we're not developers. And I feel like I'm living in an alternative universe after hearing Mr. Boffo come up and make all the statements that he made, which I just kept gasping at. That's not true. That's not what I've read. That's not what science says. That's not good for the environment. So after careful consideration, the TEC decided not to pass an ordinance permitting any use of artificial or synthetic materials as plants or ground cover, thus necessitating that an applicant has to apply for a variance which allows review of each individual situation and its accumulative effect on our environment. Today, these two requests from the same person for artificial turf, which is not allowed by our city ordinance and land development regulations. Consider the accumulated effect of higher heat, microplastic particles flowing into storm water runoff, the aesthetics of large areas covered in plastic, and the rules, the ordinance. Ignorance of the law is not justification. Titusville has not got a lot of things correct over the years. They've passed ordinances that favor developers over the rights of citizens many times in the past and have had to defend some particularly egregious crimes against the environment by paying large fines, making massive physical corrections, and spending large sums of taxpayer dollars on outside legal counsel to protect their positions. But the ordinance against artificial turf is one of the soundest environment protection laws on our books. It states simply and often that artificial turf and synthetic plant material is not allowed. Period. Stop. End of discussion. Code Section 30-321, synthetic plants prohibited. Synthetic or artificial material in the form of trees, shrubs, ground covers, vines, or artificial turf shall not be used in lieu of the plant requirements. The plant requirements in this section called for in Section C, ground cover, and D, lawn grass, real plants. Last year, the issue came up before City Council. The staff sought clarification on the use of any artificial or synthetic plant material. It was decided to prohibit the use of anything artificial and to encourage the use of native plants throughout our city. This is not the first time I've stood before this board to shed light on the harm of artificial turf to our endangered environment. It breaks down into non-biodegradable chemicals which leach into groundwater. It's not friendly to pollinators. Its heat absorption raises the temperature, creating problems for pets and children. And I have another paragraph, but I'll stop now. Thank you very much, and I've urge you
Thank
to
you.
deny this.
All right. Do we have any other cards?
Michael Myjack?
Good evening, sir. Your name and address for the record, please.
Good evening, Michael Myjack, Titusville, and I'm your chair for our Titusville Environmental Commission. I spoke to you on several occasions before, although some of you are newer. I'm going to say the same thing that we said before. There is no place in Titusville for artificial turf. It really doesn't need to be in our environment. It breaks down into things that are not biodegradable. We've talked about this on a couple of occasions. The difficulty here is what the state is attempting to do. And while we made a good change, a good faith change to our city's ordinance, our staff has not moved it forward to city council yet because of what the state's trying to do. Now, if they go and do the same thing that they did with plastic bags and single-use plastic and say that we are not allowed to deny it, then we have to figure out how we're going to allow it. And I would recommend that if we're going to allow it, it would need to be with a complete leachate field so that the leachate can be maintained and captured, just like you would with a lined landfill, which is where this stuff goes after we're done with it. Any polyethylene, polypropylene, it ends up in the landfill where it takes up space, and it does so in a way that's not going to interfere with the rest of the environment. That's not the case here when it's laying out on the land, and you guys know that. So please deny this variance. Thank you.
Thank you, sir.
Stan
Do we have-
Johnston?
Stan Johnson, yes, sir.
Stan Johnson, 860 Poinsettia Avenue. I want to first thank you for your unselfish dedication to serve on this board. I know it's a sacrifice on your part. Thank you very much. I've listened to both sides of this, and I'm not going to speak further. I'm concerned about, even if it's a law, even if it's a law of the city of Titusville, there's an ex post facto situation here in that they were allowed to put it down, and I'm sympathetic with the owners also. So I won't speak any further. Thank you.
Thank you, sir.
That's the last one on that item.
Do we want to go ahead and call up the witnesses for the next issue, or the next, or should we vote on this first?
I would recommend concluding the item variance number 10-2025 before you move on to the next item.
Okay. Discussion or comments? At the last meeting, we declined. Of course, that was for putting it down before. I am sympathetic with the owners in a way that sympathetic that they listen to people selling grass or selling the artificial turf and not coming to the city and asking, was this a rule? We've had this come up several times, and we asked for clarification, and the city is still waiting. So I don't know what to do about something that's already in place.
If I may, ask Council Ian, the status of the statute that's moving through, where is it now?
It completed its cycle through the House of Representatives for the state of Florida, and it will go before the governor for his signature, and that's what we would be waiting for to see if the state law changes.
Okay, but how long would it be before they set? I know there's a law, and then there's time for staff to make all
Well,
the rulings.
the legislative session has concluded, well, the legislative development of this bill has concluded, but I believe that the governor has until the end of June to sign the bills.
I know, but does it set the standard? I mean, it,
Standard would be established by rules set by DEP. That's how the legislation has been drafted. And then DEP would then need to engage in rulemaking, which has not started.
so.
I don't know how long that would take.
It could be
But
a
then
while.
what it says is the local jurisdiction cannot regulate or prohibit anything that is regulated, that is allowed by DEP. So we kind of have to wait and see what those rules are, and I'm sure that staff will be evaluating the proposed legislation and informing council of their recommendations for any code changes.
But aren't we supposed to consider whether at this point in time, if he's in compliance or not? That's what we're voting on, not on what's coming down the road, right?
Yeah, so that's future legislation that we've talked about because of the proposed code change. And that's the reason why the code change hasn't moved forward is because of the state legislation. What is before you tonight is whether or not the property located at 3041 Eddington Drive is allowed to have the artificial turf as it was presented before you tonight, based on our current code and not considering the legislation that may or may not change in the future.
Thank you. All right, any other discussion or thoughts on this?
I don't think it leaves us a lot of room to do anything other than deny it.
Okay. They can't hear you, sir. I'm sorry.
My apologies. I don't think the advice from council gives us much room to do anything other than evaluate and see that it's not allowed.
And is another option available where they could withdraw their request? Or like we did with the last hearing, the other 4 properties where he withdrew, waiting. Of course, the turf wasn't installed. Yes, it was. On the other properties?
Yes.
Oh.
The 4 properties in the right-of-way
So-
for the previous turfs was already installed.
So would it be an option for these 2 homeowners to withdraw their request?
So that's just admitting they're out of compliance.
Yeah, at any point before the motion is made, a applicant can withdraw their application if that's their desire. I don't see them expressing that desire.
Okay. Thank you.
The problem being, it's already in the code enforcement, that's correct? It's a code enforcement action?
Yes, that's correct.
So then it's up to code enforcement if they want to go forward with it. Okay. Do I have a motion?
Mr. Chairman, the applicant would like to make another comment if that's possible.
The applicant, will you speak again?
On both of our houses, we're joining. My parents live next to us.
Sir, if you want to speak, you have to be up at the
go up to the
podium. You're allowed to
microphone, please.
chance a rebuttal.
There are other property owners within our development that are here. They would all attest to the way that we've installed ours versus the way that the developer did are totally different. The pictures that you have within your packet show that. This was not a fly-by-night, throw it down, rake it out, try to solve a problem that he created with a very poor irrigation system that put drip lining underneath the sand, that all it did was erode the sand and create puddles in all of our yards. It was horrible. If you would have seen the mold pipes sticking up all the time, and of course, once you bust one of those or they run them over with lawnmowers, all it is geysers, and all your, city water is being spewed out everywhere. This was a correct installation of the product. We did not look to break an ordinance. The other thing I would bring up, if this was prohibited materials, why does the city not mandate a permit for it? That would have stopped all of this.
Because it's denied, it's denied, period, so there's no permit for it.
There is no permit. They don't allow it. Did you ask for a permit?
We asked all 3 contractors that we were working with.
I
was there any
understand you asked the
permitting?
contractors.
I understand where you're going with that. All I'm saying is if we look at this, the other thing I would request then is with legislation that's coming down. You look in other counties, you look in Viera, the entire sports complex, 15 or 16 soccer fields are done in this. If we're worried about leaching of materials and everything else that's happening, which way does St. John's run? South to north. All of that offlow that's coming from there would be coming here. You go up to Chain of Lakes. Guess what's behind the concession stand under the pavilion? Anyone know? I'm up there with my boys. They play soccer. It's artificial turf. This is spread more throughout the county and throughout the state than probably what you realize. And most of it is installed properly. We were, the only reason this even came up was because of the way the contractor in our development just came and threw stuff down willy-nilly and tried to pass it. He came to us and asked, hey, how did you have this done? We explained to him. We explained the tens of thousands of dollars spent to put this down properly. And he's like, I'm not doing that. I'm raking out the sand and let it be. I'm like, you're probably going to create a bigger problem for our entire community. We happen to be the victims now of something that we didn't realize was going to happen. So if anything, I would ask for at least a pause on this until there is better information, allows the city to do more research on the harms or not harms of this product versus making us pull up something that cost between me and my parents close to $70,000 to install. This was not a cheap circumstance, and this will create a hardship on a citizen or citizens and some that are on, fixed incomes.
Well, that was our request earlier. Would you prefer to withdraw this before we make a ruling?
If I withdraw it, then what happens? Then I'm in uncompliance with city
Then you
code
have
and
to
code
talk with
enforcement.
city code enforcement people, and
And I
that
have
would
to
be
pay
your
a fine
negotiation.
every month? What does that look like?
I can't answer that question.
It's an option I would encourage you to consider.
Okay.
As opposed to digging up your whole yard.
Mr. Chairman, we could consider tabling the issue for 30, 60 days, time certain, till the next meeting.
You can't continue it beyond 1 month with the current advertising. It would be a consideration.
One month?
If you were to continue the item greater than 30 days, it would have to be re-advertised.
It's 30 days. And it may shine a clearer light on it by then.
I'm fine with it. It's just, everybody else? He said tabling for 30 days to see if there's a clearer light from the legislature on this.
He's out of compliance, period. And I think we need to find that and then let code. He's out of compliance, period. And I think our job is to answer whether he's out of compliance or not to base on what we think is coming down the road, but let code enforcement deal with that if the rules are changed later or whatever. But I don't think I'm for, continuing it.
Thank you, sir.
I don't see how we could have allowed at the last hearing for that contractor to be allowed to withdraw his request for us to approve it or deny it, because he felt like it was going to be denied. We allowed that. How could we not allow him to withdraw his?
He can.
I know you want to continue it,
withdraw it.
but
He's saying he won't withdraw
better for
it.
him to withdraw it than continue?
We can't force somebody to withdraw. He would like to have a decision made by this board.
Okay, nope, you're right, you're right.
My recommendation would be to table this for 30 days and engage a different agency and talk to them about it. But that's me.
All right, do I have a motion from anyone?
I move to table the motion, table the variance request for 30 days.
I second it.
We have a motion, and we have a second. Do we have any other discussion? May I have roll call, please?
May I interrupt before that? Is there any additional information or specific information that you're looking for from either the applicant or the city in the meantime?
We're looking for information from the state as a result of their activity related to the item.
So the city can provide the legislative analysis for the proposed bill. I can't think of anything else, but we can include that in your agenda packet if you do end up tabling it, I propose.
That would enable the code enforcement group to talk to the applicant about moving forward.
This board has no jurisdiction over code enforcement. They're completely separate departments, and what happens with code enforcement is separate from your decision.
Okay, we had a motion to table. We had a second. Any further discussion? Roll call, please.
Chairman Taylor,
Yes.
Vice Chairwoman Van Deven,
Yes.
Member Beckles,
No.
Member Green,
Yes.
Member Wheelis.
Yes.
Okay, we've tabled it till our next meeting, certain, for context on what happens with the legislature is new information, which will be on our packet, hopefully. And that will be on, what's the date?
May 28th,
May 28th?
2025, yes, sir.
All right,
So that was for variance number 10. You still have to make a motion for variance number 11-2025.
all right, yeah. So that was the first one. Do I have a motion on the other variance, 11, 2025?
I have a motion to table it for 30 days on variance number 11, 2025 at 3042 Eddington Drive.
Do I have a second? I have a second. Any further discussion? Seeing none, roll call.
Chairman Taylor,
Yes.
Vice Chairwoman Van Deven,
Yes.
Member Beckles,
No.
Member Green,
Yes.
Member Wheelis.
Yes.
Okay. So both these have been tabled at this time for next month's meeting, and hopefully the state will have some definitive answers to go forward with that. Okay. All right. That completes our new business. At this point, we are open to petitions and requests from the public present. Yeah, boy.
Good evening. My name is Katie Delaney. I am not here tonight to speak to you all as the County Commissioner for District 1. I'm putting on my other hat as the Brevard County Chairperson for Moms for America.
For who? I'm sorry.
Moms for America.
Moms of America. Okay, I'm
Yeah.
sorry, I didn't hear that.
And I wasn't going to speak tonight. I was here to support the residents of Royal Oak. But what I saw happen tonight, the clear violation of somebody's First Amendment rights, I could not sit by and not say something. And I just had to say, while you may not be elected officials, you've decided to accept the responsibility of being on this decision-making board. This is not an advisory board. You are decision makers, and that is huge. your decisions affect your neighbors with no input required from the current elected officials. So yielding to board's decisions from years ago should not be your practice, in my opinion. With that being said, I'd like to shift my comment to the larger issue I witnessed tonight, the violation of a citizen's First Amendment rights. And I would like to direct you to the 11th Circuit Court decision on October 8th, 2024, regarding the reinforcement ruling on free speech. I was a named plaintiff on a lawsuit regarding free speech against a governing body of this county. And we got this decision. It was 3 years of fighting to get this decision to reinforce free speech in this county. Not only did you violate someone's right tonight, but you also put a Titusville police officer in a horrible situation to either deny an unlawful order or violate a citizen's right, which they swore an oath to uphold the constitutional rights and the Constitution of this great country. I implore you to look up that lawsuit. It's fresh, only since October. And with you all being decision makers here, it's important that you understand the laws of this land. Thank you so much.
Is there anyone else who wishes to speak? Yes, sir.
Just real quick, I'm just going to ask. James Troutman, 1705 Barna Avenue. I'm actually coming to ask for a motion. I guess that would be the correct verbiage, correct? All of our other boards, minus the planning and zoning, as far as that I am aware, allow for the alternate members not to partake, I guess as far as conversation goes, things of that nature. Planning and zoning does allow, they had adopted something in their verbiage that allows them to have their alternates be able to pretty much partake, but they don't have the ability to vote or anything of that nature unless they are sitting on the dais. What I'm asking is a motion to see if alternate members on this board can have that same ability that the planning and zoning has, as far as their alternates being able to partake and educate and, you know, pretty much be a part of the situation. So when they do sit on these boards, they're a little bit more seasoned, so to speak. Their interaction, sitting up here speaking, nerves, all that goes into play, right? So more interaction with that helps with that, and just the education of it all. So what I'm asking is if y'all could make a motion to allow alternate members to partake, but not have the ability to make a decision, approve or deny, unless they are sitting on the dais for a member.
If I may, what Mr. Troutman, alternate member Troutman is asking for is an amendment to the bylaws.
Yes, thank you. Thank you.
Is that something we are allowed to do, or is that city council?
So Mr. Troutman knows that the bylaws for Planning and Zoning Commission were amended to allow the alternates to participate in discussion and provide input on agenda items as a member. I'm reading from the Planning and Zoning Commission bylaws now. It says that when they're not officially appointed by the chairman to fill in as for a absent regular member, then they may participate. But alternate members may not be permitted to vote unless appointed as a voting member, and participation shall be in compliance with resolution number 24-1997. So if this board would like to modify its bylaws to include that language, then Mr. Troutman's asking you to make that motion so that it will be put on your next agenda to discuss that content.
But again, is that something we would vote on to recommend to city council to make? Because we can't change our,
Yes, the Board of Adjustment and Appeals can change its bylaws
we can.
by motion.
by motion.
So when you say to participate but not vote, does that mean sitting up here?
Or
For any
sitting down there at a
discussion that
computer
we
with a
have?
microphone.
Right, being
Huh?
able to have communication back and forth. So say if something came up and I have background or experience in something, I might be able to talk upon that a little bit or bring some advice or anything of that nature that might give context or helpful insight.
I think maybe I'll take off next month and you can sit right here. That's the best trial by fire.
Sure, and I'm trying to allow for members or alternates to be able to have that dialect a little bit prior to sitting on that board, as it was brought that, y'all are decision makers. We would also be decision makers as well. You say fire, trial by fire, but would that be setting up somebody for success?
Probably your background, you're already set up for success. You're already set up for success. I mean, they appointed you because of your background and what an asset would be to the board. So I'm just not sure how that would work back and forth. It would be like the way we talk to Mr. Parrish or,
Correct.
I don't know how that would work.
Well, my background, I had to gain that background. I gained the OJT on the job training experience. So
Right.
that's what I'm asking is experience, is by having that communication that builds that experience to where when those alternates are asked to sit on the board, they have a little bit of experience from it because they have partaked into that communication. That's what I'm asking for.
Okay, how about I ask that we put this on the agenda for next month's meeting to discuss?
We're looking for a motion.
We're looking for a motion to put it on the agenda for
Yeah, I
next
think it
month.
has to be a motion.
Well, I can't make a motion.
I move to put the item on the agenda for next meeting.
All right, we have a motion. Do I have a second?
A second.
Yeah, all right, got a second over here. Any further discussion? Roll call, please.
Member Beckles,
Yes.
Member Green,
Yes.
Member Wheelis,
Yes.
Chairman Taylor,
Yes.
Vice Chairwoman Van Deven.
Yes.
Thank you.
Now you have to come back next meeting.
I'll be here. Thank you so much.
All right.
Tony Schiffelo, member of the Historic Preservation Board. I get to sit up there. But for 2 years, I sat over there. And the chairman of our Historic Preservation Board, which has done magnificent projects, Joinerville and Beyond, the historic tours that are online and on your phone. We have little booklets. We have several projects that in the years I've been sitting over there or up here that we've accomplished. Our chairman always let our alternates partake in the discussion, because what if one of us got sick or our child was called out of school or you had to leave, you couldn't be there, and they're not up to speed. Our alternates always attended every meeting, and they always get to speak because they're part of the group. And if something happens to one of us and the alternate has to take over, they need to be aware, because our Joinerville project didn't happen. Your projects happen in one meeting. It's somebody gets up, you either accept or deny. Our projects, we talk about it this month. Next month, we get a little research. The month after, we analyze the research, and finally 6 months later. So our process goes on. I realize it's different, but I'm speaking, I think it's really important that the alternates attend the meetings and participate as well. Thank you.
Yes, sir?
Petitions request. Stan Johnson, 860 Poinsett Avenue. Thank you again for your dedication and service on this board. And again, I'd say it's a sacrifice. Don't like to talk about this, but the city of Titusville has done some things that are crooked, that are fraud, that are just horrible. I didn't bring it with it tonight, but I have a poster, sign that I've expressed many times. It says fraud, $70,000 fraud. What's that about? In 2019, our Mayor Johnson was behind where you guys are, and he had all these books spread out. And he said, you know what this is? We've had a study by an engineering company to study Mr. Johnson's correspondence from 2012 to 2019, and it says it's just about done everything wrong, said everything wrong, wrote everything wrong. And they paid $70,000 for it. Well, it was all hoax and a scam. It doesn't exist. The report doesn't exist. City manager agreed with it and so forth. So I'm just telling you, give you an example of a hoax that happened open and notoriously right here, City Hall, in this chamber. Let me speak about Brad Parrish. Brad Parrish has done some things that are dishonest, that are false reports and so forth like that. Mr. Parrish has approved a survey, it's construction for SNJ Oaks, fully knowing that the survey has a 3-foot bust in the right-of-way. Right now, if you go to the site and you look for the northwest corner, the southeast corner, and the southwest corner, you can't find them. Neither can the survey that's doing the stakeout. It's all, so that's Brad Parrish. Brad Parrish and Peggy Bisaka approved for that project, SNJ Oaks, an 8 replacement of Mockingbird Lane to become 8 foot wide. 8 foot wide, whereas city code for the fire department is 20 feet. City code for a flag lot is 25-foot flag stem. That's what Mr. Parrish has done. What I'm saying is he's crooked, he's dishonest, he's openly and notoriously that way, just like councilors. I'm going to say, and by the way, I came through here in 1952. I moved here in 1971. This is my hometown, and what they're doing, the city of Titusville is doing, is what? It stinks. It's fraudulent. It's corrupt. Any questions? Thank you. God bless you.
All right. Is there anyone else who should speak tonight? All right, seeing none. Staff, do we have, well, now we have one. We have a continuance there on 2 of them for next month. Do we have other items on the agenda?
Yes, we have 3 variances currently that will be for new business.
Three variances. Okay.
The application period ends on this Friday, so there could potentially be more.
It could be potentially more. All right. Anything else to report to us?
No, sir.
All right. Counselor, anything from you? Okay. Members, anything? Except it's late and we want to go home? All in favor, say aye. Aye. All right, we're heading home. Thank you.